We have extensively discussed the provisions of the Insurance Act, and more specifically 64 Roman 5B, and we are allowing the appeal.
Right.
My Lord has also authored his views, supplementing the consensus.
My lords, may I mention item 49? The AAG who's leading me in the matter has tested positive for H1N1. So I would just request for a week's accommodation, my lords.
When the matter comes.
All right, all right.
Pursuant to your lordship's directions, we have returned to the CBI for issuance of red corner notice, my lords. Yesterday itself, we have written to them. Pursuant to that, they have raised certain queries. We responded that back as well. Further action is, my lord, be pending at the end of CBI now, my lords. I have the complications with me. I can hand over.
There is a learned We'll pass it over, Mr. Farsad. We'll take it up after some time.
Yes, Malad, we'll get Mr. Kaushik here then, Malad.
Correct.
Yes.
So that everyone is.
Grateful, my lords.
Thank you.
May I mention one MA to be listed urgently, Milos?
Is it listed mentioning?
No, Milos. But the issue, Milos, there is a serious difficulty. Milos has quashed 2 FIRs against us, Milos. Who are the parties who are present in the matrimonial dispute, Milos? But what had happened, Milos, after
that one matrimonial matter where your brother was there.
Yes,
personally, your brother was there.
issues, Milos, now in the trial court, Milos, petitioner is saying that FIR has also been quashed with the third party also, Milos, against the third. it's a serious difficulty with us, Miloj. Miloj, even trial court,
who was party to that order?
Miloj, the real,
Who was party? Who was
Miloj,
नहीं ये कारण है।
Miloj, the husband-wife were the parties, Miloj. FIR quest, who are the husband-wife and the real sister brothers, Miloj. There was a third FIR also, Miloj, which was opposed by the petitioner, saying that this FIR was being registered by the third party, cannot be quashed in 142. Now, Miloj, who registered that FIR, Miloj, they are also mentioned in the FIR, which has been quashed, Miloj. Now, the petitioner is confusing the Honorable Trial Court by saying that FIR is completely.
Have you quashed that also?
No, Miloj. Miloj says if Miloj will have a page number 26, Miloj has specifically mentioned in the order itself that the FIR be quashed against those who are appearing here.
Correct.
But Miloj, even though the trial court is asking for the clarification by the confusion of a petitioner.
Pass an order and then
Miloj, otherwise, Miloj, we are in a difficulty that the third FIR, which is Miloj.
just one. Thus far, no order has been passed by the High Court, by the trial court.
Miloj.
Correct?
Miloj.
Let the trial court take a view. And then
Trial court has directed us to have a clarification from the Honorable Court.
there is that order.
Miloj. Kindly have. EB. Now, this is the first, this is
There is the
FIR.
order of the trial.
Miloj, at page number 4 of my bunch. During the course of the submission, it has been warmly argued that learned counsel for accused with the FIR
It takes time, na?
Miloj,
She's not due.
but if
He's not due.
but Miloj, if Miloj will have, there is a
When
third line, however, some time to obtain clarification on
that's all right, but she's not due.
Miloj.
Then as and when she'll take.
But another difficulty with us that there, Miloj, if Miloj will recall, she was not ready to sign the application of 142. Miloj had directly asked her to sign in the.
Then no, what is that you're saying?
My difficulty is, Miloj, the entire cases, one of the case was which against with the respondent, Miloj. She left in the 142 application, Miloj. It was left.
You move an application. My lord is here only.
Miloj, we have moved an application, Miloj, but
Whatever was part of the 142, we have passed orders accordingly.
Miloj,
Both the parties signed it and accordingly we have passed an order. We are not doing any clarification thereafter.
Miloj, the difficulty is.
There is no difficulty. You are creating it for yourself.
We'll have to pass it over because some of you.
No, everybody is here, my lord.
Yes, everyone is there.
Everybody is. No, my lord, insofar as the request for blue corners notice was there, initially it was made, it was forwarded, it was issued, my lord, on Friday. Yesterday evening, we received a request for red corner converting the blue into red. There was some clarification we required. They were provided to us late in the night. My lord, morning means we'll be looking into it, processing it, my lord, forwarding it to the Interpol, my lord.
If you
Because there, but I will, my lord, what I have inquired from the officers, my lord, there could be one difficulty. Probably there is no charge sheet which has been filed against this.
He's
Okay, we'll take a call tomorrow.
Please,
Maybe.
please.
You also
please.
sister.
Meanwhile, you also get your instructions.
But there is one angle, my lord, on the last date of hearing, I had raised as an officer of court, not as a state law officer. My lord, angle with regard to the security to the my lord, judges, my lord, who has handled this case. My lord, I have jotted down, my lord, a note, my lord, for lordship may have a look at it. If lordship find it worth taking cognizance of, my lord, then
इसको घर पे जाओ फाइल के साथ ही घर पे जाओ
please.
Thank you. Tomorrow. We are not saying anything much. We say certain communications have been exchanged between the state of
Your Lordship wants, I can,
Punjab and
if Your Lordship wants, I can hand over the communication.
just one, state of Punjab and Union of India.
CBI, my Lord.
CBI,
Please.
CBI. List them all. Let's wait for this.
Grateful, my Lord.
My lords, may I request your lordship, my lords? One small special request, my lords.
Yes, yes.
My lord, she is in deathbed. My lord, I am not able,
Sorry,
my lord,
sorry.
she is in deathbed. So whether she would survive or not, I don't know. Your lords, may kindly have it out of 4 weeks, my lords. I
Want it after
4 weeks, my
No
lords.
problem.
Great.
Great.
Milords, in item 2, Milords, may the
Milords, learned age is on his enlightening code 15. So
Pass over? No problem.
No.
Pass over.
Wait, please, Milords. Item
Second.
3, I
Item
have
3.
responded back. Sorry.
Settlement.
My lords, in item 3, as my lords may remember that we had in fact paid 50 lakhs.
Then what?
Prior to the filing of the SLP also, we have paid around 1.2 crores. The total loan account that we have for 3 loan accounts, only 2 are in the subject FIR. But we are now giving a proposal to the bank for all 3 loan accounts.
That
And for
doesn't
all-
help actually.
No,
You have to
helps.
finish it off.
Yes, no, finishing it off only for all 3 loan accounts. Although only 2 are in the FIR, I am giving a proposal for all 3.
Altogether, please
And for
get
all
it done.
3, yes, for all 3, my proposal is 9 crores, which I have placed before them, but they are not agreeable. They are also asking for some more interest.
They will not-
May I just state, Mullah, this is an anticipatory bail. I'm already furnishing the entire principal amount. Now, whatever is the remainder interest, whatever they think is
What
due.
is that you say?
Gap is 60 lakhs.
They have settled the principal amount.
The gap is 60 lakhs. They are proposing 9.03. The bank has come down to 9.65. We have
No,
already
just
paid.
one. And
Lordships, it's all in writing.
what is the total outstanding of all accounts?
Across all 3 accounts, it is 11.72.
11.72 CR.
Yes, Manoj.
That is with interest. Yes, please. Yes, please.
That is his claim.
Yes, please.
And as against 11.72, you are paying how much?
9.03
9.03
in 9 installments.
spread over,
9 installments.
spread over.
9 commencing from September. Commencing September, 9 months.
How many installments?
So every month. So nine months they will pay this. Correct?
The counter proposal of the bank was as follows:
Uh-huh.
9.65 in 4 installments in percentage terms, that is 10% within 7 days, and within 3 months thereafter 30%.
But why is the gap? Why doesn't the bank agree to his proposal?
Because we've already waived off 2.5 crores.
We are just only understanding what is the parameter or the standard applied by the bank.
Parameter is as follows: the interest on his particular 3 loan accounts is 3.08 till date. We have waived it off completely, only taken the interest going back to the date of NPA.
Gentlemen, will you leave it to us? Will you leave it to us?
Mullah,
We'll put a figure.
only instructions to go up till 9.03, Mullah.
Gentlemen,
Because, yes,
9.03 and 9.65. Take instructions.
Let my lords decide.
9.03 and 9.65.
I am.
That's it?
Yes, Manoj.
That's the difference. The difference is.
That's it?
That's the difference.
You will leave it to my lord would decide the figure. Number 1. We'll give you 9 installments, no difficulty.
We're in Lordship's hands.
We'll give you 9 installments.
Yes.
Because what we are seeing is that you're putting an end to the entire litigation,
Yes, Manoj.
which has not even commenced.
Yes, Manoj.
We bow down, Manoj, and we're grateful.
So are you open to leave it to us, to my lord,
Yes, Manoj.
to decide any amount between 9.3 and 9.65?
Yes, please.
One question.
Which may I just request, since the entire whatever is, there is a full and final settlement between me and the bank, then finally, there is no reason why the criminal proceeding should then also
No, everything will go.
sway me. Yes, Manoj. Sway me and my son. Yes.
Because there are other accused persons also. So of course, against them it will continue, but Koimni at least it should go.
Qua the petitioner and his immediate family, whatever you give the names,
Yes.
all criminal proceedings would come to an end.
Yes.
Number one,
Yes.
all civil proceedings, if pending, if any, or notice or claims set out by them of civil nature will come to an end.
Yes.
What more do you need?
Yes. Absolutely.
Very lordship sense.
Ms. Swati,
Very well, Millet.
you are most disappointed.
I'm not Millet.
You are most disappointed because
I am not Millet. I'm not, and I'll tell you why, Millet. This is, in fact, it's a very large scam, Millet. The amount involved is actually more than 60 crores. I'm very happy that the bank is actually settling with them. Because it's public money ultimately, man. It's a cooperative bank. Yes, yes.
when we said you are not very happy because we are curtailing your appearances.
No, Millet, not at all. Not at all, Millet. I'm very grateful to, in fact, the bench Millets that Millets have, in fact, these are bail proceedings, Millets, but everything gets settled. Nothing like it, Millets.
We are happy to record with satisfaction the efforts put in by Ms. Swati Gardyal in helping the parties arrive at an amicable settlement. We also place on record with their precision the efforts put in by Shri Sabka Naam Aa Jayega, assistant. Having heard learned counsel for the parties, is also peruse the record. In exercise of our power, 142, the Constitution of India, we dispose of the present petition on the following mutually agreeable terms. The petitioner, Naam Aa Jayega. Petitioner is only one person, no?
Two persons, Millet. Father and
Two
son.
petitions, Millets.
Petitioner in SLP number so and so, and Naam Aa Jayega in SLP number so and so, undertake to deposit a sum of rupees 9.35 CR with the respondent bank complainant bank within a period of 9 months from today. We'll say today. The said amount shall be paid in equal installments, monthly installments. The petitioners through counsel have been appraised, have been made aware of the consequences of breach of such undertaking. In any event, let the same be furnished, filed through counsel within the next 2 working days. Mr. Lalit,
Yes.
next 2 working days, undertaking to be given here.
Yes, Millet. There's just one aspect that just needs clarification. We have deposited 50 lakhs before this honorable court.
And that will,
Our
of course, go.
understanding was that the 50 would be covered within
50 will go.
9.34.
Yes.
Yes, within 9.3.
Correct.
Yes.
Because what has been paid to him has been paid to him. What
Yes.
has been lying here will go to him. Will go towards that account.
Yes, Millet. 50 will be adjusted as against.
The sum of rupees 50 lakhs deposited before this court shall be deducted from the said amount and immediately remitted to the respondent complainant. Particulars of the bank account we supplied from the ministry, along with accrued interest of this. With the payment of the aforesaid amount, with the payment of the aforesaid amount, all claims intercede the parties to the list would stand settled. Settle and close. All claims, be it of whatever nature, close. We also quash the FIR number so and so registered against qua the present petitioners.
There are also 138 proceedings
All
in respect of checks
equally,
given in.
all criminal proceedings intercede the party.
Proceeding should.
Particulars thereof are as under shall remain, shall stand closed.
Protect it from case of non-compliance.
Respectful prayers. In case of non-compliance, we may be permitted to.
Undertaking, na? That part of the order.
One more respectful submission. Where the figure was mentioned, no cavil as to the figure. Lordship will just not accept the bank share capital because for every loan, the bank puts in its own money as margin funding. We have to reserve that money aside for every loan because we are a cooperative. The bank sets it aside from its own reserves. So whatever is the settlement, we have to accept the bank share capital. That's all.
What does that mean? We don't know. In terms of commutation, we don't know.
I have to otherwise from my share capital let go further amount of 18 lakhs per loan. Except the share capital, what he will pay me will be only that figure.
Correct.
But except the share capital may be
To the members.
It will be to the members because that is the distribution from the members that we have taken.
No bearing on that. It's basically you're saying just.
It will not have a bearing on the settlement.
I am not able to comprehend.
When I lend 100 to any person, I have to provide a security for a certain amount on my books. That's all. If Lordships closes it at 9.03, I will have to write off that security from my books, taking an additional hit on the balance sheet. It's a accounting request. That's all. Except for share capital may be mentioned. It will not come to them. I will have to.
No, but what has that got to do with the present settlement?
If it is settled at 9.030 as Lordships have indicated, on my books I will have to write off an additional 18 lakhs.
You do that, right?
But what has that got to do? Honestly, I'm not be able to.
May I be permitted one more attempt, please? If I lend him rupees 100, for example, I have collected the money from my members' minnows. They have a right to reclaim that money at certain point in time.
Yeah.
So I have to set it aside from on my balance sheet, I set it aside as security for them. It becomes share capital in the hands of the society. If I close it at 9.30 as Lordships have indicated, I have to write off that share capital in my hands and in the members' hands.
But why would you? Why would you?
Cooperative bank will know. That's how every cooperative bank works. It works on share capital basis. We keep margins on the loans as security. So whatever is the amount, they will not have to pay us extra, but except the share capital of the bank that was put aside for this particular loan is our request. That's all.
The transaction would not adversely affect the rights of the respondent vis-a-vis its shareholders.
That's also fair. That's also
yes.
Honestly, मैं तो अभी भी समझ नहीं आया, but जो भी है लिखवा दिए.
That's also fair. I have perhaps not been able to.
In fact, we don't know the accounting.
I'm highly aware.
So on petition sense, disposed of.
Grateful, Manoj. I'm very grateful, Manoj.
Give the details of the.
Yes. Yes.
138 and others.
Please,
Very grateful.
Leave करते. अगर दोनों में separate order हो सकता तो separate कर.
May please, your lordship. In this case, my lords, notices were issued by my lords, my lord. This is for cancellation of bail, my lords. Of the person, my lord, who has been accused in organized crime of leaking the question papers, my lord, of different examinations under Rajasthan Public Service Commission, my lords. And the lordship had issued.
Hey, Mr. Advocate General, much water has flown since we issued notice in this matter.
My lords, nothing has changed, my lord, so far this accused is concerned.
No, everything has changed. You have left Delhi.
Oh,
you have been elevated to a constitutional position now. So we only thought that we'll put a quietus to this matter now, because the man is behind bar, has been out now for quite some time. His act and conduct thus far, at least from the record.
But if he remains outside, my lord, then, my lord, he's been repeatedly.
We will say that is our order.
There are 12 cases pending against him, my lord, of same nature. Of same nature, my lords. He is actually, my lord, he is a professional which is engaged in committing such crime, my lord.
It is part of our order, Mr. Advocate General. It is part. We know you have been specially engaged in this matter now, but it is part of our order, and we say that should it come to the notice of the trial court that he is in any manner violating the terms of the liberty, it shall be open for them to cancel the bail. Simple as that.
But that's
That
correct,
is part
my
of
lord.
our order.
Then, my lord, the only thing is that it may be recorded that he has got a past history of committing similar nature of crime, my lord. He has been accused in
Thank you.
similar nature
Thank
of
you.
offences.
Thank you. Thank you, Mr. How's the weather out there?
It's okay, my lord. We have some rains, my lord, here.
Okay.
My learned friend is there. Everything is okay there. So we are missing him here.
Yeah, we are missing you. Hopefully, see you on Friday. Huh?
Lordships.
Yeah. See you.
On Saturday, my lords.
I don't know. You have to check up with the bar on that.
No, Saturday is open, my lord. Supreme Court is open on Saturday.
I don't know.
Yes, but this time not it is. This time it is over.
I don't know when the bars function.
I know, Lord. I know that. That is also check.
Grateful, my lord. Deeply grateful.
Please, Your Lordship.
Yes, please.
Lordship, this is an SLP filed by the state against the suspension of sentence order granted by the Honorable High Court. The sentence is for 9 years, and however, he has undergone just 1 year, 4 months when this order was passed. He was.
No,
what
has he
has-
not in the counter? They says he has undergone 9 years. No.
No, Your Lordship, 1 year, 4 months. Total sentence is 9 years. And what has been recovered from his vehicle is 1.380 kgs of wet opium. And there's an antecedent against him. Similar case.
Yes, Mr. Counsel. Yes, Mr. Counsel.
Respondent has filed a counter, Your Lordship.
No, learn counsel with the respondent, we can't hear you. आप अपना माइक ऑन करिएगा प्लीज. Problem. He can't. Is he outstation? Where is he from?
No, my lord, is at home.
In
There's
Delhi?
some difficulty.
In Delhi? He's in Delhi?
Yes, my lord.
Then we'll adjourn it some other day. We'll have.
Then adjourn the matter, my lord.
Adjourn. Put it.
Oblige, Your Lordship.
May it please. The Lordships, the mother, father, aunt, everyone's been arraigned in a case for the murder of the deceased without any shred of evidence. The Lordships, I will make the point good, but your Lordships, there is no eyewitness, there is no recovery. In fact, we had gone to the police station when the girl went missing on the same day. And the father's been inside. The trial has. Yes, Your Lord.
Have you read the order?
Yes, Your Lordships. Only 2 witnesses have been examined in the last 5 months.
What? That's the only thing?
But Your Lordships, if Your Lordships may have.
Is that the only thing in the order?
But Your Lordships, past antecedents. It's not relating to the crime that I'm accused of here. I'm accused of killing my own daughter here, which is not my antecedent. I could be a bad person elsewhere, and Your Lordships may consider Section 54 of the Evidence Act. Bad character evidence can't keep me inside in this case.
No, it is not Character, please. There are prosecutions. There are
Yes,
there
Your
are
Lordship.
cases.
But Your Lordship
So
may have.
Rule 54 applies, sir.
But Your Lordship, there has to be evidence in this case against me. The evidence against this
In a case
in this
of bail,
case.
what is to be seen?
Yes, Your Lordship.
In a case of bail, what is to be seen?
Yes, Your Lordship. But at least that is, Your Lordship, past antecedents in a bail order is for the propensity to either tamper evidence or recommit something similar.
And what
That character is, if they use it for prima facie case, that's a different.
Come here earlier in the earlier round?
Your Lordships?
Earlier, why did you come here?
Your Lordship, that was in February 2020.
In relation to the very same.
Your Lordships may turn to page 61.
We know, therefore we are
March 2025.
Yeah, asking you why did we come?
Your Lordships, March 2025. It's page 61.
Thank you, sir.
But Your Lordship may see the evidence against me. They say the 4 accused were seen in the car, not with the deceased.
Thank you, sir.
Last seen theory. But Your Lordships, if the trial is not complete in the 9 months that the High Court has granted.
You are very lucky that at least charges have been framed in 2024 matter and some of the witnesses have been examined. You're very lucky. Next case.
But much of this.
Please, my lord, at item number 7, I'm seeking for a short pass over, my lords.
My lord, I'm in custody for 4 years, my lord.
You better be there because 23 cases already.
My lord, that is, my lord, page number 100, my lord. That is this 23, my lord, from where the prosecution has taken, my lord. I have taken proper instructions, my lord. That is not there, my lord, page number 100.
Then you do one thing, na? You withdraw this petition and file with better particulars. Simple.
No, my lord, this is the particular which I have not given. This is the prosecution. My particulars are page number 100, my lord.
1 minute. Page 3, the references 23 is there.
Yes, my
in
lord.
your synopsis or in your SLP, you don't give any reference.
My lord, page number 100 I have given, my lord. Page number 100, my lord. That is what my case is, my lord. Only 9 cases. In all these cases, my lord, I have been acquitted.
And what about appeal pending? You don't say anything?
My lord, there is no appeal pending against me, my lord. Page
Did you say that no appeal is pending?
No, my lord, this is under trial case, my lord.
Sorry.
My lord, then my lord may permit me to withdraw it. My lord. My lord, once my lord has dismissed my bail application, my lord is aware, my lord, what will happen to my case, my lord.
Thank you.
So, my lord, permit me to withdraw to my lord.
After the matter was heard for some time, seeks permission to withdraw the present petition.
My lord, with liberty to
No.
renew after some time, my lord.
Grateful.
My lord, there is nothing against me, my lord. Only the circumstantial evidence, my lord.
Only circumstances against you.
My lord,
there is nothing against you, but only circumstances.
They are saying that my daughter has illicit relationship and no statement is there, my lord.
They are saying that there is nothing, but only circumstances. There are 23 cases, they are an accused, and trial has been going on, and conviction is there, acquittal is there, but circumstances against you.
65 witnesses, my lord. 27 have been examined, my lord. If my lord may give liberty, my lord.
Next case, please.
Please, your lordship. Lordship, 2 similarly placed co-accused have been granted bail by this honorable court.
Please, my lord. Your lordships were pleased to grant bail to a co-accused. I moved it after that. The High Court says there's no change circumstance. Please see your lordship's order.
Notice.
Maybe returnable at some.
Some date will be there.
Lordship. Good luck.
Only MA is there, na?
May I please, my lord? My lord, in the
You have been carrying on relationship for quite some time. Only
My lord-
thing in your favor is that you are below to 16. That's the
My lord, may kindly have page number 64, my lord, the observation of that.
Page 98, your own complaint say that 23, 24, the matter, I mean, your relationship continue, be it for whatever reason.
No, no, my lord, it was never continued, my lord.
अरे भाई देखिए ना,
My lord, my lord.
and it continued like this from 23 to 2024, page 98.
Yes, my lord. My lord, the offense was committed from 23 to 24, my lord. I am talking about that thing, my lord.
Gentlemen, please.
My lord, I was a minor girl, my lord. I had no knowledge, my lord. Since, my lord, he had locked me, my lord. My lord, see the conduct of the person, my lord. My lord, he is the younger brother of my uncle's friend, my lord. And, my lord, on the basis of that trust, my lord, I had gone to Varanasi, my lord, from Warangal, my lord.
Best case is you are not arguing. Your best case is you're a minor below 16.
My lord,
You're not arguing.
my lord, I'm saying so, my lord. My lord, in the meantime, my lord,
behalf of state, I accept notice.
Notice.
my lord, in the meantime, my lord, the impudent daughter should kindly be stayed, my lord. My lord, otherwise, my lord, he will come out of the jail, my lord. My lord, he is in custody right now, my lord. He is in custody, my lord. So, my lord, he is still in custody, my lord, because he has applied for bail, my lord, in the second bail application, my lord. So, my only submission is, my lord, till the.
You have said we are not in agreement. That's it. Respond number 2 कर दीजिएगा. Notice.
I'm deeply obliged, my lord.
Hey, please, my lord.
My lord, my submissions are threefold, my lord. But before that, I will put the fact, my lord. But here the check was dishonored on 6/3/2018, my lord. That the amendment has come under there is
Failure to deposit 20% of the check amount.
yes, my lord. Yes, my lord. I am telling, my lord, because it is not necessary, my lord. Because it is only the prospective, my lord, not retrospective. That is my submission, my lord. Here, my lord, the amendment has come on 1/9/2018, but the check was dishonored on 6/3/2018, my lord.
Pay the amount. What is the total amount?
But the difficulty is that, my lord, I'm ready to cooperate with the my lord because it is only revision, my lord.
Pay the amount. Na.
Because of that is not, my lord, I need not pay, my lord, for that, my lord, because of only prospective, my lord, because of it is not retrospective, because it was happened in, my lord, in March, my lord.
That is only with regard to appeal. This is a revision now.
Yes, my lord.
And in the revision, it is the discretion of the court.
No, my lord.
That's right.
My lord, Lordship may kindly see
There is nothing mentioned that you are not to deposit any amount.
Lordship may kindly see the provision, my lord.
Read that.
Yes, my lord. My lord, Lordship may kindly see
As far as the
148.
revision is concerned, there is nothing mentioned on that.
My lord, only that the appeal is concerned, I have to deposit 20%, my lord. Not in
As far as
revision, my lord.
revision is concerned, therefore it is the discretion of the court.
Therefore, I will
You
read,
can
my
even ask 50% to be deposited.
My lord.
And that has been upheld by the Supreme Court.
No, my lord, there is no, my lord, with great
You
respect,
see
my lord, there
that?
is no such judgment, my lord.
Okay, we are giving it now.
Please, my lord. My lord,
How do you say that?
my lord,
If there is nothing mentioned on that, it's the discretion of the revisional court. It can even go beyond below 20 if you are able to satisfy the court.
my lord, there is one aspect is there, my lord. My lord, only one aspect, my lord.
You have to pay 20%. That's nothing.
My lord, I will show the, my lord,
Two
because of,
judgments
my lord,
are against.
it is only prospective, my lord, because of my, it is not applicable to me, my lord.
Gentlemen, you argue, you appear before us day in, day out. Have you not understood the difference between revision and appeal?
No, therefore, I am saying, my lord, the 148 very specifically says about only the 20% applicable to only the appeal only, statutory appeal. Not otherwise, my lord.
The impugned order is passed in
revision, my lord.
So therefore, what is the scope of revision?
No, revision, my lord, they cannot do it, my lord.
What is the scope of revision?
No, revision is, my lord, they can admit, my lord, but they cannot impose any condition, my lord.
Dismiss.
My difficulty is this, my lord. He takes away the money, and it is very difficult for me to, my lord. Otherwise, my lord, Lordship may have only indulgence, my lord. Lordship may, I will deposit the money, but he need not withdraw, my lord. Lordship may kindly say page number 3, my lord. We can deposit it.
application before the concerned court.
Please, my lord.
And then if there is any difficulty, you come to us.
Lordship, kindly observe it, my lord, then only I can go, my lord. Otherwise, Lordship is aware about me.
Even on merits, we are not inclined to interfere. But however, considering the apprehensions vented out by the petitioner for securing the amount, if so released in favor of the respondent, we grant liberty to the petitioner to initiate appropriate proceedings in accordance with law, with further liberty to approach this court should the need so arise.
I'm so grateful. In the meanwhile, my lord, now they are saying that I have to deposit 4.
You have to.
No, 4 weeks, my lord.
How much was the time granted by the High Court?
4 weeks, my lord.
So then that is gone.
It's true, my lord. Therefore, I am before your lordships, my lord. Therefore, I am praying for another 4 weeks, my lord.
Time to deposit the amount in terms of the impugned order is further extended by 2 weeks.
I'm so grateful. I'm so grateful.
Lordship, this matter is totally covered by the judgment. My lords, for petitioner UTO Jammu and Kashmir, I am seeking an accommodation on account of personal difficulty of the arguing counsel, Mr. Razdan. This is totally covered. My lords may have it tomorrow.
Also saying so.
My lords may have it tomorrow. I have no difficulty. Obliged. Grateful, my lords. Obliged. Highly grateful.
May I please, lordships? The petitioner herein is a defendant, your lordships, in a suit for partition. It's a case of divergent finding. Trial court dismisses it, your lordships. My lordships may have the issues.
How are you affected?
My lordship, it's non-joint of necessary party. Look at how the High Court has dealt with it. My lordships may have a look at the observations. In fact, that finding has never been.
Now there is no one else.
My lordship.
No legal heirs also left.
No, lordships. The mother is alive. In fact, as far as sister is concerned, yes, okay.
That also has been said.
Mother has passed away, and in fact, the sister, her husband, and kids are alive. Where's the family?
Gone. That's what I could.
That, in fact, it actually bases itself on the memo that is filed, your lordships. In fact, okay, the lordships.
Status quo as on date.
Please go.
एक मिनट दिखाना जरा।
Your Lordship, in item 16, the issue which was raised before the trial court and Honorable High Court is the determination of the rent. Without determination of rent, the Lordship, the trial court and High Court is. Am I audible, Your Lordship? Your Lordship, in as per section 17 subclause 2, the word mention is determination of the rent. That is required to be determined first, then only the question of payment comes. So the trial court and High Court has come on a conclusion that you have not deposited the rent, the time of extension cannot be given.
No, you
Therefore,
knew what the
defense
rent was. You knew
But there
what
is
the
a
rent was.
there is a change of landlord and
Sorry.
there is a dispute.
Thank you.
Highly obliged.
May I please, your lordship?
Yes.
Lord, the petitioner before you, lord, is the plaintiff. Lord, files to recovery of the rent, not the market rent.
What
from
is
the
wrong?
tenant.
You tell us.
Not wrong the order is that the Honorable High Court has not taken into consideration the doctrine of tenant by sufferance, tenant one. It was a lease deed for a period of 15 years. And this Honorable Court has held that once that period expires by the effects of time, now there is no agreed rate of rent. It has to be the market rate of rent after the expiry of the lease deed.
The possession is with you now, na?
No, yes, Lord. Now it is with me, but I filed the suit only for the period till it expired, till the time the possession was handed over to me for 3 years.
Possession is with you.
Now, yes. I filed
Be
it for
happy
the
they-
period they were in the possession. I filed it for the period the tenant was in possession.
Be happy. Let's put a quietus to it.
Milord, the trial court Milord allowed my suit. Their appeal is dismissed. Now, Milord, only one thing has not been taken into consideration. Not only Milord, me grant me 1 minute, Milord. Milord, it was a lease deed for a period of 15 years. Now,
You know
Milord, your
that
lordship
it's a
has
public
decided.
sector undertaking and they handed over possession to you. Otherwise, to get possession was a big.
Milord, they never invested the rate of rent. It was a point of time even held by the Honorable High Court. The matter the Honorable High Court round of litigation.
Thank you.
It was upheld by the Honorable High
Thank
Court.
you, sir. Thank you.
Milord, may kindly, Milord.
We are
Only on the
complimenting you for the submissions you made.
Please. I'm grateful, Milord.
Thank you.
Wait, please, Your
Where
Lordship.
is the appointment order, sir?
So far as the petitioner is concerned, that has not been
That's
tied.
we had to see that, and it is not there, sir.
That's true, Lord. What has happened is, post this decision, that is the impugned order, as many as 8 people have been granted the benefit by the government themselves. And one more thing, Lord, I have not raised that as a ground. It's a full bench consisting of 3 honorable judges. This intra-court appeal, writ appeal 3121 of 2019, arose out of an order filed in a writ petition filed by the very petitioner and which was allowed by the senior judge of the full bench. It was pointed out, my instructions are, Exhibit P15 is the single bench order. And it actually
What is there?
No, Lordship, your Lordship would have seen cases where a person who is appointed on temporary basis, etc., asking for pay parity with a regularly employed. But here, factually, I have gone through a process of recruitment, whereas the other persons to whom benefit was granted were appointed by the headmaster because, my lord, during 1978-79.
But you're a part-time vocational teacher appointment, not correct?
No. Yeah, this post is called as.
How it is, it's a different pay scale.
They were all regularized. So far as the petitioner is concerned, he participated in the selection process after the ad hoc rule was framed. The question was whether he can claim pay parity with that part-time vocational instructors who were later on absorbed. That is the only issue.
But they were absorbed prior to 2000.
Prior to 2000, when they.
Therefore, you did not fulfill that requirement. You were appointed thereafter.
In fact,
you are not entitled to.
No, factually, I'm better placed as what my submission is.
Only because you have gone through selection.
Yes,
process.
yes, that
does not confer any right. You knew what you would get after the appointment. The pay scales were known to you. Everything was known to you.
But then, Lord, the government has extended identical benefit to people similarly situated. Lord,
It was not a case before the court.
No, this is subsequent to this impugned order.
Therefore, we can't do anything on that. How can we take that into consideration?
Your Lordship permits, I can bring
can't
them.
take it as a first instance as of now.
Sorry, sir.
Yes, Lord.
Thank you.
My lords, I'm seeking a Passover.
It's item 20. This is a legal aid matter, my lords. The suit for eviction was initially filed in 1980, my lords. by the grandmother of the present petitioner, my lord. There are on the ground of bona fide needs for the treatment of her son and the use of the present petitioner.
It is gone now.
Lord, the person now, that second generation has also expired. Now this is the third generation. This is their own premises. My lord, a very small premises in Mumbai.
Is it not a protected tenancy?
Lord, but my lord, they have been misusing the tenancy. They have sublet it. Though court have found that it is not, we could not place on record any document in support of that. But my
File
lord,
a fresh petition.
Lord, at some point of time, the person should get the premises for his own use.
Correct,
my
but
lord.
then it's a protected.
It's
there's a
more than
legislation,
around 50 years, my lord. Now the
There's a
third.
legislation.
That's right, my lord. But
So you have to.
Lord, he requires it for his own personal use because he is traveling from Pune to Mumbai.
Now today,
Now, yes.
he has to step into the witness box and say, this is my now own requirement.
That was the requirement placed in this petition also, Lord, on record. That because he was this person presently who is made petitioner, he was traveling from Pune to Mumbai for his driving work. So he wanted a premises in Mumbai. For that, this small premises is required, Lord. It's a 10 by 12 feet premises, Lord. And he belongs to a scheduled tribe, Lord.
Initiate proceedings afresh.
Lord, these are scheduled tribe people, Lord. They have a very small premises for their own
We are not,
need. Yes.
All the tenant may also be comes from the same tribe or community.
May, Lords. But my lords, he has shifted to Rajasthan. He has given it for subtenancy. Only thing is they could not bring on record any document in support of that.
Therefore,
Yes.
see, you initiate your proceedings afresh now.
Lord may give me that liberty. Will do that.
Even though we are not inclined to interfere, but however, grant liberty to the petitioner, instant petitioner, to initiate proceedings afresh on seeking ejectment of the respondent tenant on such of those grounds as would be permissible in accordance with law.
No, there is some delay that may be condoned.
Delay condoned.
Grateful, Lords.
No, please. No, this, I was.
Curator, sixth respondent. Oh, welcome, sir. Welcome. How are you, sir? All well?
And since 2010, this people have been put into litigation. In 2010, the commissioner himself says that I am entitled for the grant in post pay, and that 2010 order was never challenged, or never challenged, and nothing has happened. In 2013, my lord, he goes to the High Court. High Court only says consider his representation, nothing else. Thereafter, my lord, from 2000 to 12, this pay was paid to me, and only in 2021.
Read para 10 and 11, and what is wrong? You just point out.
Para 10 and 11, yes, my lord. I just.
What is wrong? You just tell us that.
Before para 10 and 11, my lord, your lordship kindly have para 5 for a minute. For a minute. For
What is your case? What is your case?
My case is, my lord, there are 3 units. Unit 1, Unit 2, and Unit 3. I was the senior most in the Unit 3.
Correct.
Now, this person, my opponent, respondent number 6, he was, no doubt, he was appointed in 2006.
Correct.
In that particular this thing, my lord, unit. He is not, you lordship, kindly, you lordship, that is not the issue. Issue is, my lord, there is already an order. There is already an order by the commissioner, and from 2000 to 12 have been paid.
Thank you, sir.
You lordship, may kindly consider one aspect, my lord.
They are not taking any money back from it.
No,
What
that order is there. I mean, what he says.
That's what it has been done.
The government itself says he is not entitled for that particular grant in its pay, and he himself admits in the writ code. I want to just,
matter is over.
I want to show that particular
matter is over. Thank you. On the matter is over now.
No,
matter is over now, sir.
There is a delay of some 13 days in refiling.
Delay cannot.
My appearance may be not.
Most certainly. Now, on the lighter side, and the matter is over, my lord's first appearance, so we have to honor that also.
Thank you.
How's the family?
Yes.
Item 22, my lord.
For vacating or some.
Sorry, sir.
SLB is filed with the tenant, my lord. So I seek my lord's indulgence, my lord, for vacating the premises. Sometime maybe.
Oh, how do you mortgage?
Yes, my lord. In the middle of the academic year, my
You
lord.
want time to vacate? Will give.
Yes, ma'am.
How much time?
6 months.
Huh?
6 months.
6 months. 6 months. Undertaking within 2 weeks.
Wait, please, my lords. Item 23 is the state's challenge to the order of the division bench. My lord, the facts in this case are quite
Leave it.
peculiar.
Leave it.
My lord, would my lord then consider leaving the question of law open? Because there will be a
the
lot of
attending
other
facts,
people.
no problem. The attending facts.
I am
Not
grateful.
Details are binding.
I'm so grateful.
Wait, please.
In a review petition, my lords, the writ petition came to be dismissed. But there was 0 in the writ petition. There are MBA, doctor.
Thank you.
Well, may I only make a request? Before the High Court also, I was willing to make an offer of 1 crore rupees. That is what has weighed with
Only
the
for
court.
settlement.
Settlement.
Only we'll dismiss some minutes, but are
Malas,
you there?
I
Yes,
appear
because
on behalf
otherwise-
of the respondent. I am also Malas, willing if there is a settlement on table, we are always open to
Very
that.
good.
Plus,
He's offering you 1 CR.
Malas, the issue over here is that Malas,
You tell us
this was
what you
already
want.
discussed. Malas,
You
I'll have to
see,
seek on the quantum. I'll have to seek appropriate instructions, Malas.
But in principle, you are ready that the custody, the maintenance, the marriage, all would be settled, huh?
Yes, Malas. We are also looking forward to putting quietus to the litigation and everything.
Then we'll
Malas.
refer it to mediation.
Yes, Malas.
Malas may refer it to mediation. Malas, my only request is Malas that the on merits of the case it may not be there not be any order to that. As your lordships were dismissing the SLP, Malas.
Then we'll refer to mediation.
Yes, Malas. Simply, let us not go with any prejudiced mind, Malas. We can both.
No, Malas. Absolutely no prejudice. Right? We are making that statement.
For settlement.
I'm most obliged.
Grateful.
Settlement, Supreme Court mediation.
Supreme Court.
Malas, because the respondent is from will travel from Bangalore, Malas. The appropriate
Bangalore
order.
High Court Mediation Center. Both parties will be comfortable.
My request is because I believe that there was some sort of mediation.
Then we'll say Bangalore mediation.
Bangalore. High Court.
Malas, may I request for Supreme Court Mediation Center because
we have no difficulty.
An appropriate direction be passed to the petitioner for the expenses, Malas.
That is part of our order that if whenever the wife is required to travel, the husband pays the maintenance.
First by VC and then whenever the mediator decides.
Absolutely.
I'm most
Grateful,
obliged.
Grateful, Malas.
Obliged.
Lordship, victim is
We issue notice.
delay may be condoned, your lordship.
Delay is condoned.
Also.
Item 26. There's a letter. Acha. Chalo. Letter.
My lords, in item 27, I'm appearing for the petitioner, my lords, through VC, my lords.
Yes,
My lords,
sir.
the petitioner is suffering from a critical illness
You
from
do
chronic
one
kidney
thing,
disease.
you take what do you call permanent? VRS. You take VRS.
My lords may please consider that the impugned order has been passed on the assumption that I have been serving at Ratlam for 13 years, my lords.
No,
It's
you
factually
take
incorrect, my
VRS.
lords.
Simple as that. You are unfit for serving the defense forces.
My lords, that is not the case that I'm unfit for serving
That
in
is
RPF. my
precisely
lords.
what your case is.
No, my lords, their
Thank
precise
you.
case.
Thank you.
I'm obliged.
Also requesting for a passover, your lordship.
Passover.
Passover.
Okay.
My lords may take this matter with 56 because
36, okay. 29 case, man. 29 दीजिएगा. Both discussed, sorry.
Very well, I'll leave it.
Thank you.
Wait.
Maybe the Lordship. My Lord, there was a order from this honorable court that there cannot be a direction for regulation, but the BRO was directed to frame regulations for absorption. They do not, my Lord, did not. So we preferred a contempt. In a contempt, my Lord, this honorable court said, go and challenge that part of the denial. We challenged that part of in petition, my Lord, my basic case was a writ of certiorari against denial of preparing a scheme. That has not been answered by Honorable High Court, my Lord. And Honorable Court has said regulation cannot be, directions for mandamus for regulation cannot be passed, my Lord. That's a settled provision law. There is no quarrel. And while doing so, my Lord, the earlier judgment of your Lordship passed in our case has been relied upon.
The earlier judgment in Vartak doesn't say anything, na?
If my Lord, just for a moment, my Lord, page 87, my Lord. The fate of so many thousands of persons are involved. Recently, there is a judgment of this honorable court, my Lord, in that Sirpal case, my Lord, wherein, my Lord, these contractual employees are directed to be absorbed, my Lord. My Lord, kindly page one page, my Lord. Only one page, my Lord.
My Lord reminds me that page 106, in the contempt matter also it was decided.
Contempt matter, my Lord, there was liberty granted to us to challenge, my Lord. That was never answered by the Honorable High Court, my Lord.
If you want, better you seek a review actually there.
That liberty may be granted, my Lord. That liberty may be granted, my Lord.
Seeks permission to withdraw the present petition, reserving liberty to take recourse to such remedies as are otherwise available, including initiating proceedings seeking the review of the impugned judgment.
I'm deeply
liberty to approach the court.
Deeply I'm grateful, man.
I'm simply a Wendy, my Lord. It's purely a suit of civil nature, my Lord. Civil suit is pending even. I'm
notice.
My Lord, it stays also to opposition.
Further proceedings state.
I'm grateful.
Please, Lords. Lords Honorable, High Court pleased to dismiss my criminal writ petition, Lords, only on the assertion that prima facie reading of the FIR disclose the cognizable offence without appreciating the merit that, Lords, there is a long ingoing civil dispute between the parties. Factual matters of the case, Lords, what had happened? Me and respondent number 2, petitioner number 1 and respondent number 2 has entered into a rent agreement on a said part of land of the petitioner. I annex the rent agreement on Annexure P1, my Lords. In the FIR, my Lords, which is on page number, I'm so sorry, my Lords, page number 58, my Lords. No, Lords, on 62. The FIR is alleged that, Lords, me along with my all family members reached at the place where the respondent number 2 was.
Did what?
I'm so sorry, my Lords.
And did what?
And they have attacked over the petitioner, respondent number 2, my Lords. Now, my Lords, what had happened prior to that alleged FIR, my Lords, I complained to the superintendent of police that the respondent number 2, along with their members, and with the help of the police officers, my Lords.
Seek a discharge. Thank you.
My Lords. Lords, I'll take only 60 seconds, then I'll leave it to you, my Lordships. 60 seconds only. What had happened? First, I'll moved in complaint case against the respondent number 2 for the vacating of my property.
It is a landlord-tenant dispute.
Yes, my Lords.
Notices have been exchanged.
Yes, my Lords.
Provocation.
Yes, my Lords.
We have understood that. We have read that.
Yes,
but what does the FIR say is that you trespassed and assaulted.
Yes, that's the allegation, Lord.
That's the allegation. Now, should we quash it?
Lords, the narrative story behind this FIR, my Lords, what I'm saying, that's the allegation which is being raised against me, my Lords, to suppress me, my Lords. Lords, your Lordship's judgment in Mitesh Jha, my Lords.
Thank you. Thank you.
Lord, that liberty may be given, my Lords, to approach at appropriate.
That is always there. It's a right.
May record it, my Lords, because this is prejudice to my client, my Lords, when I approach the court, my Lords. That liberty may be given, my Lords.
Recourse to such remedies as are available in accordance with that.
I'm grateful, my Lords. delay may be condoned, my lords. I'm so sorry. I'm grateful, my lords.
Need to the lordship. Very interesting question, Lord, and has not traveled to your lordships ever. One of those few cases, my lords. Now, lords, three admitted facts I want to bring to your lordship's notice, my lords. This loan, my lords, according to the complainant, was given entirely in cash. Between these group of matters, 3 crores of rupees loan given in cash, according to complainant, not according to me.
No, see, if a bank, if it ceases it to be its entity, then why do you say it is not maintainable?
Yes, I'll indicate, but I'm just giving those three undisputed facts, my lords. One loan given, my lords, of about 3 crores in cash, admittedly in 2023. 2023, my lords.
We have read the matter. We know.
Yes. Now,
Once
please.
again, we are coming into some.
So that finding of the High Court is in my favor. Let me begin with that. Please turn to page 10. Page 10 of the impugned order. Just above paragraph 8, I have cited a set of judgments which I will place before your lordships. Just above para 8. On a careful perusal of the said judgments, it is clear that if any invalid check is presented before the bank and same is dishonored, it can be said that there is no liability under 138 of Negotiable Instruments Act. This finding is in my favor by the High Court. Despite that, my caution is rejected on the ground that the return memo of the bank said insufficient funds and not invalid check. That's the only ground on which I have lost. And I'll show the series of judgments, but please see the statute first, notes. Your lordship will have to look at two statutes, the RBI Act and the Negotiable Instruments Act. I'll make it good on the reading of the provisions. And then I'll show, my lords, the views taken by different high courts. Now, kindly first have the RBI Act.
Come with this provision. We are just now thinking aloud.
Yes. So when
Doesn't
bank
it promote dishonesty?
No, it will not. I'll tell you.
No, because what will happen?
Yes.
See, the instrument becomes uncashable.
Right.
Huh?
Right.
Then ultimately, what will happen to that?
So in every case where the bank merges, my lord, in law, and I have seen, lord, fair amounts which I am going to cite, my lords. What the RBI does is that RBI gives you, my lord, the sunset period of about 6-8 months, like in this case also. That this is the notification from which this bank will no longer cease to be a scheduled bank, which is
therefore you have to go.
And these instruments will be valid for up to this date.
But suppose
like the notes, my lord, like it happens.
Just one.
Yes.
During that sunset period.
Yes.
The person becomes dishonest. Let's say you become dishonest.
So there has to be some communication. No. These are public statutory notifications.
What will happen to those cases?
Yes.
Where a person says that now.
So he'll have other remedies, not 138. He'll have remedies in criminal law. He'll have remedies in civil law.
So we are only wanting to know that why is it that this provision, those who have issued the checks, be not those transactions.
Yes.
Be not saved.
No, it will not be. In statute, it will not be. I'll show from the statute.
We are only asking you what is
it will not be
wisdom.
It will not be because it takes away.
It It will not be is what the statute says.
Well, I'll give you.
We are now into a larger picture,
Yes.
but is this statute not ultra virus?
It will not. No, just consider this example. It should answer your lordship's query.
Because the limitation is of 3 years.
I'm sorry, Lord.
The limitation is for 3 years.
It's the validity of the instrument that
The validity of the instrument can be for 3 years also, no?
6 months.
No.
Now 3 months.
Checks.
Now 3 months.
Post-dated checks.
Yes. So therefore, no.
Therefore,
let's
for
take
example,
both.
you go and take a loan today.
Yes, ma'am.
Car loan is taken.
Yes,
what
ma'am.
they do is that they all take post-dated checks.
That's correct.
For 3 years.
Once it is, my lord, post-dated checks, and the checks cease to exist in law, in eyes of law.
All right. Is that provision not ultra virus? Is what we are saying.
Lord, nobody has challenged it.
Therefore, we are only.
Answer is nobody has challenged it. No one has challenged it. And this is not the first. One second, sir. This is not the first.
We are issuing notice. Don't worry. Tell him we are issuing notice. His anxiety is more that rather than.
Complainant bank and it's the same bank.
My learned friend is right. No, he says the complainant also has an account in the same bank.
The check is on.
Yes, just generally saying.
Yes, but in law, my lord, it can have a variety of.
Facts, exactly.
Yes.
But on the legal terms.
Yes, it can have a variety of situations. The lordships are right. It can lead to dishonesty, but the dishonesty, my lord, the possible dishonesty has to be taken care of by the statute. It's not taken
Correct.
care
But
of.
then this statute not ultra virus? Ultimately, what we would say.
Nobody has challenged the notification, my lord.
Any notice can be.
There was an interim order, my lord, throughout at page 192.
Interim to continue.
192.
Or 1.
92, page 192, my lord. Para 4. No, on facts, I'll show it's a dishonest litigation by the complainant.
Past proceedings shall remain state. Further proceedings shall remain state.
Right.
Just put someone to, just.
Very rarely we get matters which have not been decided by a lordship now after 80 years.
But that's one thing which is going in our mind. Can be misused also.
Can be.
Possibility of misuse is also.
Your lordships are right. But then these are not an action done by an accused. It's by a statutory corporation, not under the RBI.
That's another aspect that has to be worked out.
If it was an act of an accused, perhaps your lordship can.
Law apart.
Yes.
Settling the position of law is one thing.
Yes, ma'am.
In the morning, I don't know whether you were here or not. Day in and day out, we are settling matters here.
That's correct.
As against a claim of 60 crore rupees, 9 crore rupees,
No, this on facts is absolutely fraudulent. I will show.
We are only saying this that it's always better to sit and sort it out.
That your lordship, sir. Will advise. Obliged.
May it please lordships. When I was working as a deputy surveyor, my lord, I was falsely implicated in that for ACB trap case, my lord. I was.
What do you want?
Notice, my lord.
Sorry.
Millets.
Not in this case.
Millets. Learners thing is decided my reputation in my favor, my lord. GOMS number was already satisfied, my lord.
Sorry. Sorry. We'll remember your face in another matter. Thank you.
37 Millets. I'm praying for a Passover. I'm led by Mr. Pava. He's on his legs in some other court, Millets.
Please, Your Lordship, this is a fresh criminal appeal. The RFSL report does not conclusively hold me guilty. The medical examiner does not find any injuries. I've already undergone 7 years, Your Lordships.
Can you come to page 70, sir?
Please.
That is the victim, na? 6-year-old child.
Yes, Your Lordship.
What does she say?
So she says that, I'll just take it.
And look at the cross-examination that the injury sustained because of,
Your Lordship, there's delay, 4 days delay also in the FIR. And Your Lordship, it's in view of the judgment passed by this court in 2023-19 SEC 2221, the prior to the examination of a child witness, her capability to examine was not adequately questioned.
No, it was. You can't.
That's a very general question. She was.
That's all right. That's what is required. And the mother is also there.
The mother says that she informed me that there is pain. She bathed her daughter.
Oh, what?
Sorry?
Pain,
Pain in abdomen.
Is for what cause?
Your Lordship, she did not say so, but she bathed the daughter. There were no injuries. The medical examination is also inconclusive.
I was telling my, I have a large team of interns and law clerks, and law interns. So I was telling them that the best of the cases are spoiled by the trial court. That one question, how cause of injury.
I agree.
And better to be quiet rather than,
Your Lordship, the delay may be connoted. It's a legal aid matter.
To ask, is the art of cross-examination.
Yes. Delay may be connoted.
Delay connoted.
Obliged.
May I please, my lord? May I please, my lord? I was muted, please, my lord. Am I audible?
$39.
May I please, my lord? I'm the petition in the matter. I'm against the 482 order which is passed by the Honorable High Court by dismissing and questioning my FIR, please, my lord. My submission is, please, my lord, that facts should not have been, the Honorable Court acted beyond the 482 prerogative, please, my lord, and considered the facts which could only be proved established in the trial, please, my lord. Para number 14 of impugned order. Page, may I please, page 12.
No, kindly come to page
Para-
32. Kindly come to page 32.
Please, my lord.
This is the contents of the FIR, na? So we have to take the FIR at the face value.
Please, my lord.
Let's read what is the criminality here. Element of
My lord, my
it's an
allegations in
out
the
and
FIR
out.
is.
It is an out and out, simple, pure civil dispute. That's about all.
But my lord, on the same day, 3 documents were prepared. All were of 2 of 1.25 crore per acre. This document was prepared of 25 lakhs per acre. So it is totally against the intent and agreement. It comes in only because of this. It could not be explained by me. How could it be forged and manipulated by the accused? It cannot be a ground to question the FIR, please, my lord.
Okay, now you got the sale was there, na?
Please, my lord. I am the seller.
No, the sale was there or no?
No, it could not be.
No,
specific performance filed by them.
Agreement to sell was there, na?
Agreement to sell, my lord.
Then who are witnesses to the agreement to the sale? Who is party to the agreement to sell? No, what we are saying is it a rustic villager, illiterate rustic villager is what we are
please,
asking?
Huh? Petition is the seller. Please, my lord.
No, is the purchaser or the seller or the witnesses, are they rustic villagers?
My lord, I am the rustic villager. I am living in village. I am the seller. This is the petition by the seller.
No problem. Only we are now prompting you, so therefore you are saying so. But tell us one thing, what is the date of the transaction?
Date of transaction is agreement dated 29/8/2018.
And what is the date of the FIR?
Sorry, my lord. Agreement dated 7/3/2019. And
what is the date of the
FIR is 13 January 2022.
22.
When the agreement was enforced against me.
1 minute. You are in Sonipat.
Please, my lord. Please, my lord.
So you are familiar with everything, na? You are worldly wise also. You have access to justice. And you know the land prices which would have risen from 2018 or 19 to 2022. And therefore you are saying that, look, a fraud has been perpetrated upon me. Thank you.
But Milord, submissions, please, Milord.
Thank
Only
you.
1 week may be given so that I may proper come physically and address my arguments.
Thank you.
Reason is
Thank
I am
you.
sitting in Chandigarh right now, please,
Oh,
Milord.
thank you.
Due
Enjoy
to heavy
your
workload.
city. Beautiful.
My Lord,
Thank
one opportunity, please, Milord, to address my arguments further.
Thank you very much. Dismiss.
I am pleased.
Item 40.
May I please your option? I may be permitted to appear online, Milord, I am on behalf of the special petitioner, Milord. The petitioner originally filed the OS, Milord. OS was a suit for eviction, Milord. And thereafter, she got an
What
ex parte
happened to the
decree.
ex parte decree? It has attained finality.
No, Milord. Then thereafter, she filed an execution application. In the execution application, the petition, the schedule of property was restored back to her possession. Then subsequently, order 9/13 was filed by the defendant, and then it was set aside only on the basis because the summons were not received by the defendant.
No, but what happened?
Then
What happened to that? It has attained finality. Those proceedings.
Presently, no OS is pending, Milord. OS is not pending, Milord. She has withdrawn the suit, Milord. Milord, the CRP is dismissed. CRP has specifically stated in para number 10 and 11 that the suit schedule properties are entirely different. Having noted that,
See, we can expedite your suit. That's what we can do.
there is no suit pending, Milord. There is no suit pending. She has
No, it has been remanded, na?
Milord, during the pendency of the CRP, she has withdrawn the suit, Milord. There is no suit pending, Milord. Now that the petitioner is reverted, she has to restore back the position as per the orders in the CRP, Milord. That is, having noted that both the schedular properties are entirely different.
Just 1 minute.
Yes, Milord.
Today, there are no proceedings pending intercity parties.
Correct, Milord.
Now, what happened to that suit ex parte decree which was set aside?
Milord, I have the instruction that the suit is no more pending, Milord. It has not attained any finality, and then she has withdrawn the suit. What has happened is she got back, because she got back her position, she has withdrawn the suit. She's 76 years, Milord.
Was it withdrawn?
Suit is withdrawn, Milord. Suit is withdrawn.
When?
During the pendency of the civil division petition, Milord.
The order is not there on record. In fact, neither have you mentioned the date on which she has withdrawn.
Date on which I also doesn't have any instruction, Milord, on that particular. I may be permitted to get instructions on that. What date she has withdrawn the suit, but presently no proceedings are pending in the trial court.
You do one thing, ma'am, what we'll tell you. You withdraw this petition and file a better petition with fresh petition with better particulars on the same and subsequent cause of action. Don't worry.
Yes,
We'll protect you.
Liberty may be granted.
It's very confusing, honestly. We had to struggle to read the matter.
Milord, the liberty may be granted.
That we have part of the order. We've given you liberty.
Much obliged.
41 adjournment.
Please, Millards, I'm seeking a short passover in this matter, Millards.
Passover.
My lords, in this, the parties had moved the joint application under Article 142. The terms for dissolution of marriage have now been met. So, if my lords would be pleased to grant the decree of divorce and quash all pending proceedings. The IA number is 148611 of 2026.
Yeah, loud. Thank you.
Very grateful. Very
Parties
attachment of the application has the main terms set out. So if that could form part of the order.
Parties are present, no?
Yes, my lord.
Yes, on video conferencing.
Oh, only the wife is there.
Respondent,
Ladies.
yes. Respondent is
Your Lordship is also present. If Your Lordship, I'll just instruct him to switch his camera on.
Apologies,
there.
Your Lordship.
So both of you have settled the matter?
We have, Your Lordship.
Okay. Thank you.
I'm so grateful, my lord.
Very grateful.
Oh, duly identified.
Which your lordship heard last week, Millards.
Item 40.
Honorable
45.
Justice, item 41 was called, may I know? I was not taken away.
45.
Renumbered as 59. 44 was deleted, it's renumbered as 59, Millards.
That's right, it will come at 59.
It will come at
45, counter not 5.
No, Millards, your lordship recalls, Millards. One opportunity given, last opportunity given. My learned friend said he doesn't want to file. Then again, last time your lordship said that. Lordship
said the local lawyer in Gujarat, they are unable to reach the client.
In fact, your lordship, I made a request, your lordship, since the court had stayed the proceedings, my lord, but it didn't come in the order. My colleague had mentioned, but your lordship said it's only coming up on 18th. So.
The factual aspects, Millards,
no problem.
would
Then
have
we
instruction, but insofar as the impugned order or the washing aspect is concerned, I can assist, my lords. But I think my lords
you
raised
file
the
your
query with respect to the ATS, which is mentioned in the complaint itself.
You file your counter, whatever it is.
Yes, ma'am.
Because the state counter 4 weeks to joint of 2 weeks.
My lords, I'm praying for a Passover in this matter.
Milord, it requires a detailed hearing because pleadings are all complete.
Sorry, sir.
Pleadings are all complete and it requires a detailed hearing because matter relating to the appointment of an assistant professor in a college.
No, sir, kindly come to page 22. In fact, why should we keep this petition pending any further?
Lordship, I appear for the state in this matter, my lord. I need some time to
Because your appointment was not in accordance with law. Yeah, you want to heard on some other day.
That is approved by the university. It has to be
no problem.
It has to be heard in detail, my lord, because I can convince your lordship.
Okay, no problem. Have we said the impugned order?
Lord,
there is no stay?
No, there is no stay.
Can they admit that? Be granted. Okay.
Lord, hearing may be expedited.
Hearing expedited.
Absolutely.
She's been deprived of the payments otherwise as per the judge's order.
Lord,
Payment as per the
agency is there with respect to
payment.
She has been given payment only from a later.
No payment, no payment.
Page 101.
Milord, page 101 of the paper.
Yeah, nothing.
Milord, one submission in that case.
Other
7 persons, teachers were appointed.
Nothing. Thank you.
Lord have granted only leave, Millards, in this matter.
Only leave. And also hearing expedited.
Lorships.
Yes, sir.
Lorships. This is coming out, arising out of a partition suit. I appear for the petitioner and all other respondents barring respondent 1. Lorships. Lorships, the issue is very small and short. There's under the land reforms a tenant who's been a tenant and declared a tenant by the land tribunal, whether the tenancy will inure to the benefit of the joint family or in his individual capacity is the issue.
We'll keep it for some other day.
Very well, Lordship.
Otherwise, point out. I've held, my lords, he was abroad. He was not cultivating it.
See, at times, what happens is, today God is with him. Because when I said we'll keep it for some other day, what I intended to say was the question we'll examine some other case. So he said, okay, thank you very much, some other day.
So I would still urge your lordships to examine the question in some other case, my lords.
Lordships, I have been benefited by the kindness of your Lordships.
Are in my favor, and he was abroad all through, my lords.
Really, there's nothing in it.
He was abroad all along.
Lordships, may I only request this?
There is nothing.
May I only request this?
Not only I am saying, my lord, independently.
Once he is abroad, he is not a cultivator under the act.
That's right.
May I only request this, Lordships? Let me make an endeavor, however small an endeavor, to convince you.
Do it today only.
Very well, Lordships. I will try.
Today.
I will try. I'll try, Lordships. Lordships, may I just show Annexure P1 first, which is the Form 7,
Correct.
by which the whole dispute began. Lordships, at page 31.
Kindly, you do one thing.
Lordships.
Kindly come to the first appellate court findings.
Lordships.
And
Lordships,
then
but
we'll
before
see-
that, just 2
1 minute. First, we'll come to the first appellate court findings and then the High Court findings.
Page 9.
Lordships, both of them are against me. Therefore,
No, what is wrong with them is what we wanted you to tell us.
before I go there, just 2 things and I'll go immediately there, Lordships. Just 2 things. In form number 7, when it is applied at page 31, Lordships may just look at the right column. The applicant himself says that from the time of my father, time immemorial and self for last 30 years. This is the application. On this application, the land tribunal gives a finding in March 1977. Lordships, now from March 1977 till January 2000, even if we take the case of the respondent number 1, there is no dispute that this Chalgani right was given in favor of the joint family. There's an alleged settlement deed on 6th of January 2000, and thereafter in June 2001, the executor of that deed, he passed away, the head of the family. Thereafter, the partition suit was filed, and the trial court decreed the partition suit. Now, the appellate court, where it has not agreed with the trial court, is only on this issue that if there was a settlement agreement entered, then without the cancellation of that settlement agreement, the declaration of partition could not have been filed. My argument today, your lordships, is this, that if in terms of form number 7, the tenancy has been given to inure to the benefit of the joint family, therefore the father could not have entered into a settlement agreement. And the law is very clear that if a document or an agreement which you could not have executed, that you need not file for cancellation. Lordships, just one more thing, since I have not been able to convince you, Lordships. Lordships, the respondent number 1 has taken contradictory stand, which is evident from his written statement filed before the trial court. Form number 7, I showed you, Lordships, where the father himself says that he's been there. His father has been.
Put a quietus to this.
Very well, Lordships. Much obliged. Much obliged.
Please, Your Lordship, I'm appearing for the petitioner. Your Lordship, this one petitioner has tendered 19 years of continuous service. He was appointed in 2007, and since then he is continuously working on the said post, Your Lordship. The petitioner is claiming regularization of his services, Your Lordship.
Yes, continue. We are hearing you.
Yes, Your Lordship. Your Lordship, in
how do you meet the eligibility criteria for 4.2? Simple
yes,
as that.
Your Lordship may have 4.2 first. Impugn order at page number 2. May I read it?
Oh, we have read it. You tell us, how do you meet?
Your Lordship, even the candidates who are being regularized, whose service are being regularized, respondent number 5
Article
to 7.
14 will not apply like that.
But Your Lordship, they are similarly placed employees are being regularized, Your Lordship.
14 is not a negative right.
Yes, but Your Lordship, even after working
You are
for,
unable to satisfy us, and we are with you.
yes, Your Lordship, even after working for 19 years, I have a legitimate expectation that my services would be regularized, Your Lordship.
Thank you, sir.
Your Lordship, even in 2013, rules were amended in 2025, Your Lordship.
We can't, we are not the legislature.
Your Lordship may kindly consider for me for a minute, Your Lordship. Your Lordship, it's been 19 years I have been continuously working on the said post, Your Lordship. My juniors are being regularized. My services are not regularized because I completed my PhD in 2011, Your Lordship.
You have to meet
Your Lordship, there is a GO of a state government which permit the employees who were initially appointed without qualification to complete their qualification. Your Lordship may kindly
But you go back, I mean, you exercise that right. Simple as that.
Your Lordship, even the relaxation was granted by the state government to the other employees to complete. There is a GO, Your Lordship,
You
of the
don't
state
challenge
government.
that. The challenge is not.
No, Your Lordship, my challenge is not. I am relying on that, Your Lordship.
Your challenge is not that on the ground that others have been given, I have not been given.
I have specifically challenged, Your Lordship, may kindly at page number 195. Your Lordship, I have specifically made an amendment, Your Lordship.
Government is something else. Challenge is not on that. Thank you.
Your Lordship, even after serving 19 years, if my services are not regularized,
No, we can't
it
do
would cause a great prejudice to me, Your Lordship.
Thank you, dear.
Your Lordship, even the 2013 regularization rules were amended in 2018 and 5 years tenure was extended to 10 years, Your Lordship. The person who has completed 10 years would be regularized. Your Lordship, in that also a cutoff date is of 2018, Your Lordship.
Well, you tell us what do we do?
Your Lordship may consider it is a legitimate expectation of an employee if he has worked for 19 years, Your Lordship. There are decent judgments, Your Lordship, in Jago and Dharam Singh. Your Lordship will consider the employees who have rendered 11.
Jago and Dharam Singh were all class 4 employees, class 3 employees.
Yes, Your Lordship.
You are not.
But Your Lordship, the continuity of service has been considered by Your Lordship. Your
Okay. Yeah. Thank you, sir.
Oblige, my lord.
I'm being led by senior advocate now. I'm seeking a short pause.
My lord, AGM is not well today, so sought accommodation for 1 week, my lord. AGM is not well today.
Acha, okay. Okay.
We have mentioned the matter.
Oh, no problem. Some date.
Much of
I kuch nahi, sir.
My lord, item 50.
Bro, this is.
My lord, item 50, I appear for the respondent. I'm seeking 4 weeks time to file counter.
Malas, this is that matter. Malas have issued a short notice. Malas on the short issue. Malas that rule 5, that suspension they have to.
No difficulty.
Malas,
My lord,
Malas, there is a retirement of Malas petitioner. The next month is due. Malas.
The matter
How will that make a difference?
Malas, that will make a difference in that manner.
Get all benefits.
Malas, it will Malas to retire with Malas a blot Malas that there should, under suspension is something which is Malas, which is something of a grave Malas prejudice to the petitioner. Malas, I'm on that limited issue only. Malas, Malas, we keep it. A short instruction is required. Malas, whether there is any article of charge, any charge sheet, any disciplinary inquiry is pending or not. That is what precisely is.
He wants time to file counter, no?
Please.
Because he wants 4 weeks. Malas, there is short instruction only. Malas, Malas have issued notice and that's why precisely has put it after 1 week. Malas, we keep it for a day or tomorrow. Malas, a short instruction is required.
1 week time.
Well, 2 weeks.
1 week. Take 1 week.
Malas, we put up a returnable date. Malas,
Date will be there.
Very well.
Oblige, Malas.
My lords, item 52, my lords, this is anticipatory bail, my lords. The petitioner is falsely implicated in the present crime, my lords, on the basis of the statement made by one of the accused.
Just 1 minute, ma'am.
Yes, my lords. My lords, the two accused who were apprehended at the premises, my lords, they are already enlarged on bail, my lords. Not present at the premises.
Be honest. Your instructions are complete, huh?
My lords, my lords, there is no recovery, my lords.
Your instructions are complete.
Yes.
Complete, na?
Yes, ma'am.
Thank you.
My lords, kindly grant some time.
Have you understood what we said? If you want time.
No, my lords.
My lord.
Okay, yes, my lords. My lords, but just one.
What time to surrender?
Yes, my lords.
How much time?
3 weeks time, my lords.
Okay, no problem. 3 weeks.
Grateful.
Surrender on of it.
Grateful, my lords.
Please, my lords. So anticipatory bail, my lords, 303.
Notice interim protection.
Grateful much.
May it please your lordship. May it please your lordship.
What is wrong with
Since 1935, Milord, she is a tenant in the house. On 3 counts, Milord, the suit for eviction was filed. Bona fide requirement, Milord, default and non-user. So far as first two counts are concerned, Milord, the suit was dismissed for separate court confirmed. The only ground on which it was decreed was non-user. Now, Milord, I have produced electricity bills to show that this was being used.
For 6 months they say it was lying.
No, that's what, Milord, they say, without looking into the fact that the electricity bill was produced, which showed that I was staying. Milord, that is the only ground. Otherwise, Milord, on other 2 counts, it was dismissed. This ground, Milord, 1935, she is staying there. 1935, Milord, Milord, almost 90 years she is staying there.
She's no more there.
She's no more now.
She's expired now.
She has died. Now
She was staying there.
she was staying. In fact,
You
she
had
was
a
staying.
separate house. You are staying separate.
She was.
So therefore, there's nothing left now. Let it go now.
Milord, may I request for time to vacate?
Time, okay, how much time?
6
You've
months.
not been staying there now.
Milord,
6 months have already
all
gone.
her
That was
belongings
big
is said.
time. For time till
6 months, Milord, your lordship.
6 months. Why
I'm so-
prolong the agony now of that person? Execution of.
May I please, Malaj? Before I start, Malaj, your lordships have passed the well-reasoned order, Malaj, allowed the civil appeal and enhanced the compensation. I'd like to point out one small error, Malaj, which is corrected. Para 12, Malaj, page 11. Malaj, while computing the monthly income, Malaj, it is taken as 1,300, Malaj. And I am covered by your lordship's own judgment in Sonia, where it said that, Malaj, in cases of MACCT cases where permanent disability is caused to minors, Malaj, the salary has to be equivalent to that of a skilled labor under the Minimum Wages Act.
No. Thereafter, we have also.
Malaj, then it'll be Malaj, he is a qualified, he has a diploma in engineering, Malaj, and has done instrumentation as well. And even though he's not working right now, Malaj, he's worked for a stint of 2 months, Malaj. At that time, Malaj, I placed it on record in the SLP, Malaj. He was getting paid around 83,000 dirhams, Malaj.
See,
Malaj, I'm only asking for that minimum amount, Malaj. May I just point out that relevant para, Malaj, please, Malaj.
55. Okay, now mind me, Thank you.
Obliged.
Yes, sir. Yeah, item 57, who's there?
My lord, I am in item 57. My lord, we are led by Mr. Huda is in court 1. I am requesting for a passover. Please, my lord.
Let's say led by Mr. Patwalia. He's on his legs in court 14. It's Passover.
My lord, arguing counsel Minesh Dubey sir is struck in election matter, sir.
Struck in elections.
Minesh Dubey sir is struck in election. So
My
kindly
lord,
stop.
it is-
Thursday, my lord.
This is the same matter
Kindly, my
that
lord.
was listed
My lord, it
yesterday.
can be
that
tomorrow,
is-
my lord.
You are unfair now.
My lord,
You are unfair. Yesterday.
I seek passover, my
notice
lord.
was issued only for the purpose of settlement, my lord.
You are unfair to the court.
I seek
Yesterday
passover, my
It was a limited notice. We'll pass it over.
lord.
Obliged.
Milord's ASG is still on his legs in another court as of now.
Sorry, my lord.
He's in which court?
Court number 3.
Just tell him that it has been passed over twice. The maximum sentence is 7 years, na?
Yes, my lords.
And out of 7 years, he's been behind bars for how long?
Now, my lords, very important thing, my lords, my additional documents, my lords. The co-accused, my lords, he is already on bail, my lords, may have that order, my lords.
1 minute, we just pass it. Pass. Tell him he has to be. Exactly.
Yes, my lord. Lord, in the cancellation bail petition, my lord, there were the 3 legitimate points were raised, my lord. One is there was a deliberate cancellation of the criminal incidents while securing the bail, my lord. And we have filed on record at page 19.
You had argued earlier this was dismissed. Can't recap that matter again.
My lord, even after the bail, the key witness, the crucial eyewitness has been turned hostile, my lord, because of the threat he has admitted in the cross-examination, my lord. Kindly see, my lord, the page 79.
Finally come to page Y.
Yes.
Page Y.
Page Y.
Your synopsis.
Yes.
Your second bail application is on this ground. That he has been intimidating the witness and therefore the witness is turned hostile.
Yes, my lord.
Now, either the witness will be hauled up for perjury or it's a case of mistrial. And what is that action which you have taken after PW19 testimony was required?
When the PW19 turned hostile, my lord, thereafter we
Then
filed
what
a
did you do?
cancellation application, my lord, before the learned High Court.
Where is the cancellation application?
Page
Page 87.
Page 87, my lord.
Okay, what is
And kindly see the paragraph, my lord.
Page 87, what
4, 5, 6, and 7, my lord.
What do you say? Please read it loudly.
Yes, my lord. That after the accused were enlarged on the bail, the said eyewitness has turned hostile during the trial, resulting from his earlier statement. That the change in the testimony is not voluntary, but is a direct consequence of the threat, intimidation.
Who has filed this application?
The informant, my lord.
Informant.
Yes, my lord.
Where is the affidavit of the informant? Where is the affidavit of the informant?
Informant means, my lord, the original complainant who registered the FIR,
Yes.
Jagdish Sharma.
So we are saying
Yes, ma'am.
these are bold assertions that PW19 has become hostile only because there were threats.
Yes, ma'am.
Threats extended when, how, which place, you're silent.
Yes, ma'am.
As silent as you could be. And as my lord said it, in the first round, the SLP was dismissed.
Yes, ma'am.
And now, this bold application, the assertion in this application is neither supported by any affidavit of yours, nor is it give any specific particulars as to how the liberty has been misused or threat has been extended. These are the only 2 grounds, para 6 and 7.
Yes, madam. And one more ground, my lord. When the matter was called for the final hearing on that day, the bar in the Rajasthan was on a strike. The strike notice is also on the record. And so I was not given an opportunity of being heard, my lord.
Heard when?
Yes, 93, page 93, my lord. We have annexed the strike notice of the bar. On that day, the matter was dismissed.
In which case?
In the present case, my lord, when my cancellation bail application was listed.
Cancellation or grant of bail?
No, cancellation bail application was listed before the High Court.
So when your page 87 application was decided, you were not heard?
Yes, my lord. Page 93, we have annexed the bar notice, a strike notice issued by the bar.
In your petition before the High Court.
Yes, madam.
Where do you say this fact that you were not heard?
In the High Court, no, my lord. When the petition was listed before the final hearing, my lord, I could not appear because the strike called by the bar. This is my ground, my lord.
Gentlemen, what was the date of the strike?
24th of April, my lord. 25th of April, 26.
But the impugned
Page
order,
94 and 95. Yes.
the impugned order is 25th. 25th.
Yes, my 25th. Yes, my lord.
It was strike on the.
Yes, my lord. Yes, my lord. As per the notice, my lord. Kindly see page 95.
Yes, no one is open. Early noticing. Notice to Learned Counsel points out, inviting our attention to para 1 of the impugned order. Learned Counsel as also application page 70. What was the page?
93, my lord. 9345.
No, 93 नहीं होगा. Also application page 87. And the notice issued by the Bar Association, page 93. Invite her. मैंने fold कर दिया. And then on 3 pages I folded. Then notice returnable code private party does the service through SH.
Amlesh.
Lord, around 346, my lord. Gram Sevaks are before my lords. The learned single judge decided in my favor, and it was reversed by the division bench, relying upon some directive, my lord, which will not have any effect on the rules, my lord, the amended rules, which is at page 108. I'll just take away, my lords, to 108. These are the rules which got amended on 14th of August 1998. Now, please see, through the notification mentioned, the Gujarat State Civil Service Revision of Pay Rules 1998 have come into effect on 1st January 1996. As a result of this pay revision, the higher pay scale scheme implemented through the resolution mentioned in Preamble 1.2 is revised as follows.
Note.
Lord, may I seek my lord's Dustin, Lord Dustin edition?
No, State of Gujarat is here.
Very well, please.
We record their presence.
Please,
We always
Great.
record their presence.
Great.
Serve copy on them.
Wait, please, my lord.
Serve the copy on them.
Yeah, please look.
Lords, there are 3 submissions for your lordship's kind consideration. The first submission, my lords, is we are only aggrieved by 3 paragraphs of the High Court judgment, paras 18, 19, and 21, because the other paragraphs relate to respondent number 1. Yes.
My lords, there is an application filed by the college for vacation of the stay.
That's all right.
That is listed today.
We have seen, the date is 18th. We are.
The application for seeking vacation of the stay granted on 21st of July, that is listed today for hearing.
Sir, page 7, we've seen list again on 18.8. We have seen that.
The main petition as well as an application.
We've seen that.
Yes.
So you accept notice.
One submission. One submission.
Yes.
Now kindly have, my lords, page.
What we will do is, we will not pass any interim order, and we'll await the outcome. We'll say, in fact,
I go to proceed.
High Court may decide the case.
May I just point out something to my lords? By this order, insofar as my client is concerned, I was working since 2025. They have granted final relief by staying, my lords. I am agreed with that. So that's the problem. Even though his writ petition has been dismissed by the single judge, at an interim stage, the division bench is granting a stay, which effectively means I am out.
ले लीजिएगा. Then you are for whom?
R1.
R1, my lords.
R1.
Yes, sir.
We can do is, we'll have to protect his interest because he has been officiating. We are telling you, he has been officiating.
Please, please.
Thus far, he has been officiating. So we can say that he will continue to officiate, and we'll say that we request the High Court to decide the matter on expeditious basis.
Lordship, please.
You can dispose it off.
Yes, yes.
And
Nobody will,
this can
your
be
lordship may
disposed.
say nobody will take an adjournment. It can be disposed of on the next date.
All contentions are left open.
Very well. Right.
Is interfering with the college proceedings.
It's a very fair.
That's good.
Yes, sir.
Please say what.
Take care of it.
Interfere.
Having heard learned counsel for the petitioner and state का हाजिरी लगा लीजिएगा, appearing parties कर दीजिएगा. We have the considered view that the interest of justice would be best met with the disposal of the present petition in the following terms. A, the petitioner shall continue to officiate at the
Post of principal.
last place of posting.
Lordship, please.
Posting to the efficacy of the impugned order shall stay. To that extent, we request the High Court to take up the main matter and decide the same on an expeditious basis. Parties present before us undertake to fully cooperate and not take any unnecessary adjournment. See, we leave all contentions are left open.
Obliged.
Timeline.
My lords, some time limit because earlier we came to this honorable court.
Within a period of 3 months.
3 months.
The judge has to write a judgment also.
Grateful.
May it please all of you. The High Court takes a divergent view to the coordinate bench, dismisses my petition. Similarly situated candidate, where the High Court allows, your lordship confirm that order. Merely because a question of law is kept open, the High Court takes a divergent view, completely divergent view. I'll show those orders.
The Carter rules are at page 144.
Yes.
Mr. Chaudhary,
Yes.
tell us how best we can help you because Carter rules are totally different for.
No, what happens here is, my lord.
See, these are two separate cadres and streams, please.
Let me tell you.
I hope we are clear.
I understand, my lord, what the High Court has said and what your lordships are saying. Now, what happens is this. Now,
What the High Court has said, we'll examine that, but I hope we are clear that what.
yes. I have understood what you're saying.
Shikshak Karam.
Shikshak Karmachari.
Two different cadres.
Right. Now, my lord, what they do is they transfer us from one department to the other. My lord, what happens is, my lord, this government resolution of 2017, that's the subject matter, which says that if you put in 10 years of service, you get next promotional pay scale. Now, my lord, this was the very my lord, claim of the other person who claimed the same benefit. which the High Court allows.
Can we only suggest one thing? We have lost advisory jurisdiction. Go back to the High Court, you will save the day.
No, no, my lord, that, what I'm requesting, my lords, your lordship may issue notice. Let them come and say, my lord, because I am covered by your lordship judgment, which says that once I'm an employee of the government, my lord, it does not matter, my lord, whether the schools are run by the panchayat or by the government. That's what your lordships have said. Now I'll show those judgments also. And that's the reason why, my lord,
Go back to the High Court.
then your lordship may permit me to challenge this order also again.
Otherwise, no
yeah.
problem. No problem.
Otherwise, what happens?
We'll do that.
Yes.
We'll grant you further liberty. No?
Yes, yes.
That is fine. No? That's fine.
Yeah.
That's all right, na?
Yes, yes.
You have instructions, na?
Yes, yes, yes.
There are certain things left best unsaid.
Yes, very well.
Same order. Seeks permission to withdraw the present petition, reserving liberty to seek initiate appropriate proceedings, including seeking review of the impugned judgment, with further liberty to approach this court on the same and subsequent cause of action.
I am so obliged. I am so obliged.
Obliged.
I am so obliged.
और सब समझ गए हैं.
Please, Your Lordship. I'm sorry I was not here, my lords. My partner.
No problem. No problem, sir.
My lords, we are the parents of a soldier who is martyred, my lords. And it's our case that the respondent never married to the deceased son. The family court, the High Court, in all the rounds we succeeded. The family court.
Possibility of mediation.
My lords, I'm open to work it out.
Please, why we say mediation? Prima facie, let us tell you, we are
Yes,
not with you.
Not
Prima facie, we are not with you.
my lords.
Because you yourself have admitted the relationship. Only because marriage had not taken place according to you, the fact is that they were living together.
My lords, I can.
1 minute.
I'm sorry.
We are telling you.
I'm sorry, my lords. I'm sorry.
But why we want mediation? So that, the acrimony, and that too over a dead son and a dead husband, should be over.
I bow down.
For that purpose.
I bow down. I bow down.
Not otherwise.
I bow down, my lords. I bow down.
And if we dismiss it today, the scars will continue
Till the last day of. I agree, my lords.
Yeah, that's the only thing.
Lordship may consider.
No issue, my lords. But only it must be restricted to mediation, my lords.
ये क्या बात हो गई,
That-
Mr. You are
that-
standing here.
And they are continuing to draw the pension, my lords, despite the order
That's
of the
all right.
Honorable High Courts. Despite the contrary order of the Honorable High Courts. So they are continuing to draw the pension, so they may be stopped from drawing the pension, my lords.
Not in this manner.
Opportunity has been given before the district and before the High Court, but they didn't turn up for a mediation.
And conduct about that mediation, that they have never participated in mediation before the High Courts and also before the District Court, my lords. And twice they have been given opportunity and they have not, my lords.
Ma'am, what's her name? My apologies. Rohini, we'll request you to sit with me. Just sit with me. My apologies, I am not able to recollect your name, but you are quite familiar. You practice in this court, you appear frequently, and we have great faith in you. I'm sure you will be able to, heal these scars.
I'm sure she will.
Ma'am Kaleja, we request her to sit with the parties and help them arrive. And then, okay, sir.
Much obliged. Much obliged. Okay, for the indulgence. Please, lordships.
They shall make themselves available in her office on date de dijiye, the time and all.
Yes, sir. Lordship.
I'm seeking a short accommodation for donation. May I have it next Tuesday?
No problem.
My lords, appointment orders have been issued. Quietus can be given to this litigation, my lords.
Next Tuesday, my lord.
I have the appointment.
That is subject to SLP, my lord. That is subject to the
The
outcome.
government
SLP.
itself has issued a memo permitting BTech students to participate in the
It says
process.
subject to the outcome.
They have conceded.
So we'll say in view of this action taken, petition disposed of.
My lords, may have it next Tuesday.
Why?
They are arguing.
No, my
there are
lords,
certain.
it is all subject to minutes. We are all selected candidates.
We are saying
Yes.
that now the government has taken the decision, therefore we close these proceedings.
No, my lords, I
2023, the government issues a memo permitting us to participate. We are BTech degree holders, my lords.
That is made a part.
Thereafter, they issue me an appointment letter and they write a clause stating it's subject. Next week, my lords.
Next week.
We
may explain.
Okay.
Nothing, sir.
Complete your instructions, okay?
Please.
My lords have.
Yes, Mr. Huda.
My lords have adjourned that matter, my lords.
Yeah, yes.
Lord, the trial court had summoned the additional 4 accused under 319.
One minute, Mr. Huda. Please, just this minute. So.
Lord, I was a BDS doctor before marriage, and they got me married to Mukesh, who was already married. Marriage was subsisting. Lord, the first marriage is dated, and those facts are not in dispute, Lord. 8th of October 2012.
उसको भी जोड़ लीजिएगा. Anyone in the neighborhood who has been left out, he can also be named.
Lord, I would humbly submit. There are specific allegations, threefold allegations so far as one Tina is concerned, the sister-in-law. She knew about the factum of the first marriage, subsisting marriage, don't disclose it, and Lord, they spoil my life. She demanded a dowry. There is a specific allegation in the FIR, specific allegation in my statement before the court. Third, there is a specific allegation that she retained my jewelry when I was thrown out. So far as other 3 accused persons are concerned, which are uncle, auntie, and the cousin, the only allegation, my lord, is that they were all aware.
See, the main accused, the primary.
Please.
The prosecution is continuing for them.
Father-in-law, mother-in-law, and the husband, yes.
Correct.
But my lord, MBBS young doctor and the entire family will collude and will not disclose that there is a subsisting marriage, my lord. That need to be taken into account.
No problem. Just what is, let's put it differently.
Please, my lord.
How best can this issue be resolved?
My lord, now they
finally resolved. No, we are not talking of this case.
Please, my lord.
How best this issue can be resolved?
Because, my lord, Preeti is still the wife. And there was a matrimonial MSCT case going on in Delhi between this Mukesh and Preeti. And when I sought an impediment in that case, Mukesh withdrew that case. That is Annexure P12 is the order, my lord.
Let's see what happens.
So grateful. My lord, may kindly stay the...
something, but be ready. The mere issuance of notice.
I bow down. My lord, I quite see the observations, my lord, that I quite follow. But one more indulgence. In the meantime, trial may be stayed, my lord, because against the, though, my lord, I am the complainant. Because if the trial concludes in the meantime, then the purpose will get defeated.
Do you think the trials will conclude first?
Yes, my lord, that's right. My lord, it is at a different stage.
The defense.
That's right. That's why I'm saying, otherwise I would not have made that stay. Grateful. Much obliged. Much. May please, Your Lordship. Lordship, in yesterday order, in place of 10 a.m., it may kindly be made 7 a.m. on 20th, Your Lordship. Yes, Your Lordship, because if it starts early in the morning at 7 a.m.,
7 a.m.
by 1 we have to report it.
7 a.m. आज का दीजिएगा. Today's proceedings. As requested by the state, the timing
on 20th.
For 20th is changed from 10 a.m. to 7 a.m.
Yes, sir.
But now we are the home guards. Now,
many of
yes, we are total about 360, 370.
just listen to us first, and then you make your assumptions. Tomorrow is a matter which is fixed.
Correct.
We have the bench has great faith in him, if not in his clients. We are using this expression deliberately because he has assured us something, and we see no reason. It's the face of the state. We see no reason as to why he would not honor his word, or the state would not honor his word. If tomorrow everything is it turns out to be good, as we have discussed, then the natural course and corollary would be that you would also be there. That is one way of looking at it. The other way of looking at it is that you please make your submissions, and then we'll take a.
Your Lordship, may I just make one submission, Your Lordship. There is some problem in their case, Your Lordship. There is a judgment of High Court. They come up with a challenge to the Jharkhand Adhiniyam, Your Lordship. May I just read out one paragraph from that judgment, and that is actually running in our neck, Your Lordship, because with that direction being there, Your Lordship, it will be actually going against the direction of the court.
वो तो हम set aside कर देंगे.
But I have my friend is on a very different tangent. I have something completely different to say. In the High Court, when we went, we competed in pursuance to a particular advertisement where 50% posts were reserved for us. After we had worked for about 10 to 12 years, they told us, you don't make the cutoff mark. We had a grievance. We said under the manual, there cannot be a cutoff mark. We could not persuade the High Court. We came here, Your Lordships have issued notice. Today, I am not standing here before Your Lordships on that basis. I have two very independent and separate bases to be standing here before Your Lordships.
We know that.
My first base is that when Your Lordship asked them to make the whole list of all those who would be affected, Your Lordship found there were 2380 total vacancies, out of which 1168 were female and 1212 were male. Then Your Lordship asked them, how many are the total people here before us on this day? Total were 888, which included about 360 of us. Your Lordship made that order that day for all 888. In the course of the writing of that order, when Your Lordship recapitulated the earlier position, Your Lordship referred to an way earlier order where Your Lordship had said, those who have passed the test, you can do it. But then that order, Your Lordship, in the next line of the same para 10 says it was modified in January 24. Now, they don't look at the modification, they look at the order. That's one thing. That we were part of this whole homogeneous group before Your Lordship, which were intended to be absorbed. One. Two, I have a far greater claim, if I can use such a strong word. We have worked for 15 years on these very posts on which we want absorption. They are not asking us to go home today. They are happy to allow us to work as home guards. And this test physical which they are taking, they took this test when we were recruited 15 years ago. We passed this test and got recruited home guards. Every year there is a review physical test for us, which we are passing. So, my lord, today my friend is still trying to cling on to that judgment and that advertisement. That I respectfully submit. In doing so, perhaps the main crucial point is being completely missed. And that point is, somewhere along the way, we became part of a homogeneous batch
because the vacancies kept for us were being utilized for those people. Today, if he's, so that is one. Two, my lord, I say that we have worked for 15 years. And your lordships now in Jito and all those judgments of Justice Vikramath, there are about 10 judgments in a row where he say where your lordships have said that you can't wish away these people who have worked for 15 years saying backdoor this that. Your lordship's view is everybody should be regularized, given a regular status. So, my lord, I cannot understand. COVID we have faced, the students' agitation on which he was saying that there is a students' agitation which is called off yesterday, that I can't do the test. Our clients were there on duty in that student agitation. COVID we have done duty. Naxalite duties we are doing. You are not asking us to go home. But when after 15 years we come and say that we are part of a group, please give us something, then you are opposing. Rather, there is no test even necessary, my lord. Your lordships can, I understand what my friend is saying.
He, that we could gather, he is not opposing. He says that there is some hurdle which has to be crossed. So to that we said that don't worry, we will be able to deal with that issue. We told him that.
May just say one more thing, Your Lordship. Your Lordship, number one is the judgment. Number two, Your Lordship, that tomorrow the people who are called, Your Lordship, they are 451 in number. Their roll number, etc., have been published in the 7-day notice which was given to them, Your Lordship. The second thing. Third thing, Your Lordship, 356 is the number which they are saying that they are here. Suppose if tomorrow this judgment is to be set aside, then whatever is the issue, it will be open to much more people, even those who are not here, Your Lordship. It cannot be such, Your Lordship, because if there are home guards, Your Lordship.
Don't worry, you leave it to us. Don't worry.
Okay, Lordship. Okay, Lordship. I'm just flagging the issues, Your Lordship.
Mr. Patwali is not agreeing to that suggestion. Huh?
Which
It has to be argued.
Which one?
Because there's one
Lord, other people, other people have been excluded who has not come by a cutoff date are out for everybody. Now he can't.
What we can do, Mr. Patwali, is this: you take your choice. We'll just because we have one more matter, we can come back and hear you. No difficulty. You want to take it up tomorrow? We'll depending upon what the outcome is, we'll take it up tomorrow. Whatever time, whatever you wish, we leave it at that.
No, we can do it. Your lordship wants to hear the main SLP itself?
Because you see, the main SLP can't be taken up today, and it can't be decided. So we'll have to adjourn.
What I can do is, I can make a written. We'll make a written note and hand it to your lordships. What more do I have to argue?
Lordship there is already burdened with so many.
Please. My lord, I can just by tomorrow morning, 10:30.
The only thing is that we can't get
2 pages.
Well, what we'll do is, to be fair to you also, we'll endeavor to deliver the judgment if at all it is there. If it is not delivered, then we'll have to take it up after Monday. We'll be
all right. So what I can do is, your lordship can close this. I have nothing more to say. I am coming on a different basis. I am coming on a very different.
It is to be heard also, na? See, it is.
Your lordship can keep it end of the board tomorrow. Then, if my friend wants to.
Tomorrow, yes, I have no issue, your lordship. I am here.
Tomorrow.
I can. What I can do, very frankly speaking, beyond what I have said, I have nothing to say. I don't have anything else to say. So I can put it in 2 pages and give it to your lordships. No problem.
And your lordship, we have, luckily for this week, we have one more day.
Yes.
Yes, you brought that.
No. In fact, my lord, in this whole situation, there is only one person who can solve everybody's problems.
That is your lordship.
No.
That is your lordship.
So that is the person who can say that, all right, for 15 years, if a person has served my state and he is getting a regular status, where is the problem?
Yes.
Much obliged. Yes.
Thank you.
My lords, besides the 358 candidates, my lords, we are also representing 58 candidates. We have filed our supplementary
But these are beyond the cutoff. These are beyond the cutoff.
My lords, but as per the order, it says every candidate who has approached any high court will pay.
Lordship, no more.
No. These are beyond the cut.
No more new matters.
And they are not part of
My
your
lords,
lordship.
We are not opening up.
Similarly situated.
Yeah, we are not opening up now. No.
They are beyond the cutoff.
It was 60 years. 60 items. 60.
Sir, I have instruction to withdraw the petition.
Takes permission to withdraw the present. Ma'am, are you happy now?
My poor clients, my lord, every day they call me to check
No,
what is
that's all
happening.
right.
Only
He's
notice
withdrawn
was
the
issued for
petition. That's
mediation.
it.
Yes, my lord. Thank you. I'm highly obliged.
Item 2.
May I please, my lords? I'm so
No.
sorry that I was not there. My lords.
See, for 3.5 years, he's been behind
Yes, my
bars.
lords.
And the maximum sentence which can be imposed
It's 10 years, my lords.
is 7 years.
10 years, my
Oh,
lord.
my lord.
Actually, in
10
under
years.
section 5 of the Assam Protection of Interest of Depositors, it is 10 years, my lords.
Now, my lords, that is for that purpose, my lords. I just wanted to show the order of additional
Please
documents
see
at
on
page 44, my lords.
page C,
The co-accused
page C
has
of
already
the
granted
petition.
the already granted bail by the session.
Yeah, we are granting bail. Bail.
May I please, my
Much
lords?
obliged.
One should not come in the way of the discretion of my lords. My lords.
Much obliged, my
Very, very kind of, very gracious on your part.
Much obliged, my lords.
2 बजे है ना 2 बजे
Wait, please, my lords. My lords, in terms of the judgment delivered by my lords, we have filed a compliance affidavit that may be taken for a moment.
Yes, Punjab's also filed, however, the same is not on record, my lords. We have filed it yesterday only.
Page 2 of the compliance affidavit.
We have not gone through it. Can we have it tomorrow at 12:30? We'll go through it.
My lords, just one small request, my lords, because matter is being listed tomorrow, our affidavits would not come on record, my lords. May directly affidavits be come on record.
I just had one issue, my lords, that I wanted to flag before my lords. 23.10 of the judgment. That says, my lords, that if after the ANPR cameras capture the vehicles which are uninsured, then the fuel would be stopped, a pilot project, my lords. And in the end, it says that MOPNG in principle does not have an issue. But the problem is that MOPNG, my lords, is not the implementing authority. And it will be the state government, and there'll have to be a wider consultation on.
You may do that.
My lords, for the moment, my lords, after we have a deliberation, then only we can.
See, we have said as a pilot project. Therefore, we have said you start with Delhi.
Well, what I suggest is if we capture the uninsured vehicles and we send challans to their respective addresses.
Ultimately, this menace will be over only when you will link it to the petrol pump. We would have issued directions. We said so that we are not issuing directions only because of Puttu Swami. So if you were to come and you start as a pilot project on a pilot project basis in Delhi or any metro or any.
The ministry's apprehension was that tomorrow there might be some law and order situation if the fuel is stopped for some vehicles. Then
you start with Delhi. Start with Lutens in Delhi. No problem. You have to start. You have to start somewhere.
Plus, I'll make submissions tomorrow on this.
Yes. I just have one submission to make. Would Millards kindly have para 34 of the judgment? Millards, we have complied. Millards, in short, insurance company pays the quantum. So the respondent complainant as rightly submitted by the claimant's respondents in accordance with the circular of IRDA dated 16th November 2009. Insurance companies are liable to compensate for any occupant in the vehicle under a comprehensive policy. Millards, here is where the discomfort lies for the simple reason, Millards, this circular does not apply to the owner driver. So, Millards, we have complied. Millards may exercise powers under 142. But, Millards, to apply this circular, Millards, would upset the proposition, Millards, which has already been settled. Because if I may just show this circular for a moment.
We are not modifying.
May I only show the circular?
We are not modifying.
Millards, may I only for a moment?
No. Sorry.
Millards, in fact, this issue is also pending before a larger bench.
You may do. You may.
Convince the larger bench.
Millards, I'll show. That's my only concern today. We have complied with the direction.
Thank you. We'll have it tomorrow.
No.
Millards, may kindly.
Tomorrow's lunch, Milord.
Post lunch, there is.
We'll be filing.
At lunch.
Millards, kindly direct. Millards will have to give that.
Ma'am, mangwa lijiyega afterwards. Whosoever wants to file whatever may do so. Just give it in court or file it and then call for it.
Millards, it's already filed. Just needs to be taken on it. Very well.
Obligements.
May it please, my lords. My lords had asked us to hand over a short note.
No, have you received the copy of the?
We have, my lord.
Lord, may I submit something?
So there are
Lord, may I submit? Lord, payment is being made, 65% almost, my Lord, is already made, and rest is in the process. Lord, your Lordships have appointed Justice Indu Malhotra to supervise, my Lord, this payment. There is some issue regarding, Lord, the rate calculation, my Lord. It is raised by them, my Lord, not by us. Lord, either your Lordships will have to decide or it can be left to Justice Malhotra. Lord, we can file either our response here or before her. Whichever way, my Lord, your Lordship finds it appropriate.
My lords, may I clarify what the issue is that is being placed before my lords with the solicitor?
Received as per the report of the.
My lords, there are a number of people who have not even received some money.
The report, to the best of our recollection, says that about 7,700 crores has been disbursed to the employees.
Yes.
Is that factually correct? Some may have received, some may not have received. That's a different matter.
My lords, I'm on the word
Only
disbursed.
fraction of the
Because
dues.
what is being included, my lords, what is being included in the disbursal is them putting some money in a provident fund account with a lock-in period of 24 months that I don't have access to. So for the majority of employees, groups A, B, and C,
The money has come to you.
it's not come to me. It's come to an account somewhere that I don't have access to it. And
It is not in your account.
it is in a provident fund account that I do not have access to.
It is your provident fund account.
But I can't withdraw it.
But then it is your account.
It is in my account. That's fair, my lords. It's in my account. But there is a lock-in period of 24 months.
But it has been dispersed by them. See, they are out
Fair
of
enough.
pocket. It is not that.
I take what's
Yes,
falling
sure.
from my lords. But my lords, the difficulty is
Well,
that
well,
my
I think
lords
this-
had, in fact, if my lords remember in the interim order, said that the urgency is such that at least 25% should be released
The
immediately.
disbursement alert is not really reaching everywhere where
One
the
thing is
people are
there.
not entitled to get it.
Mr. Bhattacharya, I think must first acknowledge and appreciate one fact that at least you have got 7,700 crores. Please, 700 crores. The committee has done its job.
7,700, yes.
7,000 crores has been.
7,700 crores.
That's a fraction of it.
24. Why this lock-in period of 24 months? Who is appearing for the?
The solicitors appearing, my lords.
I am appearing for the state.
Why this lock-in period? Where is that lock-in period in our judgment?
Lord, this is raised, but not orally for the first time. I may not be able to immediately respond.
My lords,
Many things have been
it's
done
in
without in
writing as
violation
well.
of the judgment.
In multiple places, and in fact they had made the submission before the committee, and the committee has recorded it, that there is a lock-in period of, and I can point that out, it's in my note. I'll do that,
Lord,
my
note,
lords.
Lord, if there is any problem, if there is any prayer, then let them move an application. I can, my Lord, at least respond. Lord, if a note is handed over, my Lord, how do I respond? How do I take instruction? I'll have to file an affidavit if required.
But it's already, this is not, the fact is not disputed that there is a lock-in period.
Your Lordship said, Lord, in your Lordship's judgment, Para 59.7, I'll just read for half a minute. The import of the committee shall be in consultation with the state authority to determine. Three things were there, my Lord. Total amount, schedule, and periodically verified. Not all parties, my Lord, could not, my Lord, approach the committee or were not invited. If, my Lord, everybody is invited, so our say, my Lord, it would be before the committee. Because of
No,
non-presence, my Lord.
just I propose to your suggestion.
Yes, sir.
See, we don't. Who would go before the committee? One representative. No, you see, everyone can't go before the committee.
They've been hearing us, my lords. We were there. There are three,
One
four parties.
representative
They were
from
hearing
the
us. There's
petitioners and
no
others who have
problem with
joined.
that.
That's all, my Lord.
Because there are various parts of the elephant, my lords. It's the entire state of West Bengal employees.
You do one thing. You tell us who amongst you, by name, would be representing your interest before the committee. We'll permit you the gentleman to, if the person to appear before the committee.
Yes, my lords.
We agree with that.
No, we don't know. You'll have to you have to give us a.
We'll make a list. We'll consult everyone. We'll make a list and we'll give it to my lords.
So far as Confederation of State Government Employees, Mr. Firdaus Shami will be there. I give it here and now.
No, but everyone has to agree to that name.
Yeah.
No, on behalf of the different, there are only 3 parties, my lords.
Therefore,
for unity, my learned friend appears for unity.
I will represent for 2 and 4.
My lords, for Unity Forum, there will be 2 representatives because there are some factions that have emerged. So there will be 2 representatives for 2 and 4. We can give the names.
what we can do is that whether it is 1 person, 2 persons, 3 persons, 5 persons, you sit, decide, and give us the names.
We'll do that.
And we will authorize them to make to appear for the committee and appraise them or whatever you have to say.
I'll get that done. I'll make a list,
Well,
my lords.
it's
We'll compile it.
better with 1 person from the one organization, not too many numbers. That will create chaos.
We don't know this. Mr. Bhattacharya, all of you, therefore we are saying, all of you, please sit down and give us 5 names or 2 names.
Okay.
That's it.
We'll do that, my lords.
Audit so that there is no confusion and there is.
And it's an ongoing process. The committee is monitoring it.
Some deliberation.
And so therefore the committee will apply its mind, listen to the Solicitor General, representative of the Solicitor General, and then take a view.
My lords, there is just one main point, however, for my lord's consideration. My lord, if my lord would be kind enough to turn to my note at point 5.
I don't have a note, my lord. Better if she really has a problem, let her file an application.
Let me just say, my lord, we don't
cannot
even
be
need
just
the
said,
note.
my lord. We have to
We don't
respond
need
also.
the note. They have
Mr. Solicitor, just 1 minute. Just 1 minute. What we can do is, what is that you wish to say? Just tell us.
My lords, the learned solicitor had placed that there is an ex post facto calculation of not the AICPI on which my lord's judgment had turned. My lords had said.
What is that you want? You tell us.
So what I want is for my lord's judgment to be honored. My lord had said that the AICPI should be the basis for the payment. They've calculated something else.
So there you tell the committee. No difficulty.
And with leave to come back, my lords.
It's an ongoing process. We are not.
Fair enough.
Dispose of the
Fair
matter.
enough, my lords. Fair enough.
In the committee, my lord, your lordship's court is always.
So you give us the names, and we'll say.
I'll give only 1 name, my lord.
We don't know.
Give it away.
Gentlemen, please, all of you on this side or this side, whichever, other than this Union of other than the state of West Bengal, would have to tell us who are the persons by name.
Yes,
who would be authorized to appear before the committee on behalf of everyone.
I will give the list, my lords.
Okay, that's better. মলয় মুখার্জির নামটা দিতে মলয় মুখার্জি না শ্যামল মিত্র not Firdaus, sorry. শ্যামল মিত্র should be there.
We'll keep it tomorrow. Tomorrow.
Okay.
List tomorrow.
Deeply obliged.
Our order dated so and so.
Your lordship is ensuring, my lord, that it comes to an honorable end. We are
Yes, our order dated so and so stands last order complied with as paid for list tomorrow at 2 p.m.
So grateful, my lord.
Thank you. Thank you.
Just 1 second, sir.